Hey, good evening, everyone. Welcome to the April 2nd, 2019 meeting of the Hamilton Planning Board. I'm Brian Stein, the chair. We have a number of things on our agenda tonight. One being the first public hearing for a medical marijuana facility site plan review and stormwater management permit at 654 Asbury Street. We also have a continued public hearing for a definitive subdivision application at 46 and 48 Meyer Road. And we have some other board business, our housing master planning update, and potential minor revote on the signage bylaw tonight. So I've already talked to the applicant for the medical marijuana facility, and he's agreed to go second tonight instead of first on the agenda, provided that everybody for 46 and 48 Meyer Road is here. I don't know. Do you know about if everybody's here for your side at least? And
yes.
Is anybody here represent? Okay. Yeah. All right. Thanks. So please.
Thank you. I'm Peter Nectum from McLean, Holloway, Doherty, and Sheehan in Peabody. I'm here on behalf of my clients Nazir Shamsuddin, Patricia Shamsuddin of 203 Cutler Road. I just want to thank you again for the opportunity to address you tonight. I have with me Bob Griffin here from Griffin Engineering to discuss the revisions to the project plans which were submitted on February 11th of this year, and to again review the waivers from your subdivision regulations that we're requesting for this project. As you know, since we were last before the board on January 29, Mr. Griffin met with the fire chief, Mr. Brunette, and satisfied the fire department with regard to the proposed improvements to the private way. I believe that Chief Brunette has submitted a letter to the board to that effect. Tonight, we're asking you to approve the revised subdivision plan and requests for waivers. I understand that there's some objection to this project from the neighbors, but I just ask that you keep in mind tonight that what the Shamsuddins are proposing greatly improves upon the current and dangerous, as acknowledged by the fire department, conditions of the private way. If there's anything you'd like me to address at this point, I'm happy to do so. Otherwise, I'm prepared to let Mr. Griffin take you through the revisions to the plan and the waivers that we're requesting from you tonight.
Great. Any questions from the board? Okay. Feel free to, Bob.
Yeah, I'll just briefly show you what the revisions were that were provided last month. Actually, 2 months ago.
Yeah,
when we were here at the end of January, we showed this particular graphic.
Can you just grab the microphone so people on TV can hear you? Thanks.
So when we were here in January, we showed this particular graphic, which shows a separation of a hammerhead turnaround and the Lot 3 driveway. This we had prepared in response to some comments that had come up a few days before the last meeting. So after our meeting, we had an opportunity to review this particular layout with Chief Brunette. He thought it was a favorable modification. He also asked that in addition to the layout that we had shown here, that we widen the roadway from 20 feet wide to 22 feet wide. So we did that. And I'm going to just come around to the other side for a minute. So if we look at our plans, just a modification to the cover sheet indicating that some revisions were made. Sheet C1 was our existing conditions plan, which no change to existing conditions, so there's no change to that drawing. I'm sorry. This is our plan of land, which shows our proposed lot lines. No change to the proposed lot lines. No change to our existing conditions on C2. And here's our change to Lot 3, showing the separated driveway here. There was a couple things that came along with this. One was the addition of a sign at this location here. The sign says, "No parking, fire lane." We had also moved a hydrant a few feet closer to the hammerhead so that if a fire truck did come down to this area, it would be a convenient place for the fire truck to tie into the fire hydrant. Excuse me. We moved a catch basin, and then the drain line continues to go out where it used to go, but there was a modification to the location of the catch basins here and here. There's a small retaining wall that was added from here to here. This has a maximum height of about 3 feet. It would be constructed of segmental blocks, and this just is required because of the increasing width of the roadway and the embankment that comes up in this particular direction. So we basically have left the roadway in the same alignment, just sort of made it a little bit wider to accommodate the fire chief's request. This change also gets reflected on the typical section of the roadway. So instead of a 20-foot wide roadway, we have a 22-foot wide roadway. So that's really the extent of our modifications to the plan. Be happy to address any questions.
Given you had to add the retaining wall, whose responsibility is that for maintaining that?
So it's the same as the roadway. It belongs to the people that live along the private way.
Any questions from the board? Yeah, one sec. Chris, I was going to have you kind of just give us your quick background on everything. I know you wrote us a letter and a memo, but just so everyone here can kind of hear the legal aspects around this, our attorney, Chris Heap, is here to address that.
Absolutely. This application is certainly unusual in the I think amount of legal issues that it presents. But when we last spoke from the last session of the public hearing at the end of January, the board had just heard from the attorney for the abutters, the McGuires, and who had also submitted a letter to the board. And as we broke then, the board tasked us with coming up with reviewing all of the arguments that were presented in that letter and coming up with a response. We've done that. We submitted a letter to the board outlining our positions. And although, like I said earlier, this application does present a number of legal issues, I don't believe that any of them result in the board not being able to grant the relief that's been applied for. I think this is something that the board can proceed with. But dealing with all of the arguments in a little bit more detail, and to walk through the letter that you got from the abutters attorney, argument by argument. The attorney makes 3 primary arguments in the letter that was dated January 29th. The first is that parcel C, which is shown on a 1956 plan and makes up part of this proposed subdivision, is subject to a condition that limits that lot to 1 dwelling only. The second argument presented in the letter is that lot 28, which is shown on a 1960 plan and makes up the back portion of this proposed subdivision, is also subject to a condition that limits that lot to 1 dwelling only. Those arguments are both factually accurate insofar as those lots are both shown on old plans that have conditions written on them that say there can be only 1 dwelling per lot. But the key point, I think, with respect to those is that those are permitting conditions that were imposed on plans quite some time ago. And the property owner is absolutely allowed to come back in before the board with a new application and ask to do something new or different with their property. And the question when that happens is the new proposal something that is consistent with your subdivision with the subdivision control law and consistent with your subdivision regulations. The mere fact that there's an old condition that exists on the plan does not mean that that condition remains true forever, or that that property is forever restricted to 1 dwelling per lot. If they come back in with a new application for a new definitive subdivision plan, your job is to look at the access that they're proposing, the drainage that they're proposing, and attempt to determine whether those are consistent with, I think, your subdivision regulations and other developments that you would customarily permit in town. Again, the mere existence of the condition is not dispositive of what can and can't happen at the property if they provide you with a new application. Now, following up on that point, one thing I'd add is that to some extent because they're effectively asking that a condition on an old plan be varied or taken away, to some extent what we're talking about here is a modification of an old plan. And there is there's a statute which is Chapter 41, Section 81W, that generally states that no old subdivision plan can be modified if the modification is going to affect lots in the subdivision that have been sold or mortgaged in good faith. So there's an argument that I anticipate we might hear when we hear from the Abutters Council that you can't eliminate that old condition off of those old plans without the permission of all the other property owners shown on those old plans. But I think the key point in response to that argument is the words "shall affect" and what that means under the subdivision control law. The words "affect" under the subdivision control law mean things like changing lot lines or doing things that are going to affect the lots that have already been sold out. Here, where what we're talking about doing is having the applicant do work within a 50-foot wide right-of-way that has already been shown on a plan and has already exists as a matter of record, without changing any lot lines for any other property owners that were shown on those old plans. It's our opinion that the changes don't affect the other property owners shown on those plans within the meaning of the subdivision control law. There's a case that says any number of physical changes affect, in greater or lesser degree, lots in a subdivision. Examples: location of trees, width of streets, planting between the curb and lot lines, traffic signals, overhead or underground utilities, or street lighting. They do not, however, limit the utility of those lots, and hence do not affect them in the statutory sense. The plaintiff's complaints about traffic or an unwanted backyard neighbor are a matter with which Section 81W is unconcerned. So there's just the mere fact that something is happening and an old condition is being removed doesn't mean that the other lots are being affected or that this modification would require the agreement of everybody else shown on those old plans. The third argument presented in the January 29th letter is that the backland, which is shown as Lot 28 on the 1960 plan, does not abut the 50-foot wide private right-of-way, and therefore doesn't have rights to use that private right-of-way. As you can, I don't know if you can all remember the old plans, but Parcel C, which is the front part, abuts the private right-of-way. Lot 28 is behind it and does not. And because Parcel C is the only part that connects to the private right-of-way, the argument is that Lot 28 can't access the property that way. That's an accurate description of the plan, but based on our review of the case law, it's our belief that as long as there's no structures built on the property and back, on the land formerly shown as Lot 28, that the use of the 50-foot wide private right-of-way would not overburden the easement. They can drive up and down it to use it to access the property, but as long as there's no structures in back, that would be okay. And I've shared my reading of the case law on overburdening of easements with the applicant's attorney, and it's my understanding that they would be content to limit the actual development of the property to what was formerly shown as Parcel C, which is the part that actually abuts the 50-foot wide private right-of-way. Finally, there's one argument I want to bring up, and that is with respect to the deed to the land that we're talking about now, and I think it may be helpful for this if I pass out the old subdivision plans, or the old plans to this area. And this is a collection of, I think, most of the important old plans showing all of the land around the 50-foot wide way. But the first one on top is the 1955 plan. It's got 1956 in the corner, but I think this one's dated 55 in the bottom right. And this is the deed. This is the plan by which Parcel A on top and Parcel B were first conveyed out into separate ownership. I believe I've spoken with the abutter's attorney, and I understand that he believes that the way the property was conveyed out was such that the owners of Parcel A, or the successors in title of Parcel A, wouldn't have actual rights to use so much of the private way as is shown within the bounds of Parcel B, which is the part on the bottom. And that's because in the deed in which the successors entitled to parcel A conveyed out parcel B for the first time to a separate owner, the deed says describes the right-of-way as follows. It says, said premises are conveyed together with a right-of-way over the southerly portion of the private way. Sorry, and this is the deed in which. Sorry, if you turn the page, I'm on the wrong plan. No, I had the right one. First page, sorry. Okay, and the deed in which the owner of parcel A conveyed, well, the owner of all the land conveyed parcel B out for the first time. The language describing the right-of-way says, the deed to parcel B says, said premises are conveyed together with the right-of-way over the southerly portion of the private way, and the grantors reserve a right-of-way over the northerly portion of the private way shown on said plan, which is actually backwards. What was happening there is the owner of parcel A was reserving a right-of-way over the southerly portion and conveying out a right-of-way over the northerly portion. I've reviewed that deed language, a million times, and the only way that I can read that language to make any sense is that the language is backwards. And so the owner of parcel A had a right-of-way over the southerly portion, and the owner of parcel B had a right-of-way over the northerly portion, which is just not exactly what it says in the deed, but is clearly, I believe, what was meant and what actually happened after that. So those are my responses to the argument, to the legal arguments that were presented to the board the last time around. That's all I've got for now, but I'm certainly happy to answer any questions that the board has. But again, in summary, this application throws a number of legal questions in front of the board, or I should back up even further, raises a number of legal questions. I think a lot of them are actually title questions. And there may be title questions that may eventually need to be figured out as between the private property owners here, because title questions really are not ones for the planning board to decide. You guys are a planning board, and you are properly concerned with matters that are raised under the subdivision control law, with access, with traffic, with drainage, with environmental matters, but you are not, in the end, the final arbiter of who's got title to do what. That's really the responsibility of a land court judge, not you. You have to sort of dabble in those waters sometimes when presented with applications like this. And we've looked at these questions, and to the best of our ability, we think that there is nothing that would prevent the board from granting the relief that's been applied for. But just as if we get any deeper into these questions, I would just always want to fall back to the position that these are not always things that the board is best suited to decide.
Thanks, Chris.
And with that, I'd be happy to answer any questions.
Could you just repeat the very last sentence? It's conclusionary, but I couldn't hear what you said.
Just that sometimes the board has to look into title questions to see if somebody has the right to use a piece of land for access. But where these questions get especially complicated, they become things that I think are properly decided by a court, not by the board. It is really matters of access, drainage, traffic, environmental that the board is, should be looking at when reviewing an application of this type.
Thank you.
Thanks, Chris. Any other questions?
Yeah, Chris, just clarify in my mind.
Yep.
When you were talking about the northerly and southerly portion,
Yep.
I think of the right-of-way, and you think that the document you were referring to was reversed. Did you come to that conclusion because parcel B is southerly to parcel A, that parcel A is more in the north and parcel B is in the south, and it couldn't be done the way it was really written in the document?
I think of parcel B as being southerly of parcel A. I do.
It's south of
Yep.
parcel A.
Yep.
Yeah, absolutely.
Yep.
Okay, thanks.
Sure.
Thanks, Chris.
Hi, I'm Dan Pasquarello. I represent the McGuires. Do I need to move this, or is this okay?
It's fine with us, yeah.
Can I just move it back a little bit?
You can take it down.
My periphery, sorry. So I think Mr. Heap is correct in what he just told you at the end of his presentation, which is that there is no express easement to this property. Now, I respect Mr. Heap's opinion that it's his interpretation that you could make this finding, but respectfully, you don't have the authority as a planning board to do that. A court would have to come in and establish easement rights in this case, because what's lacking here, and I'll go back to some of the points about the January 29 letter that I submitted that Mr. Heap just addressed, but one of the things we didn't address in the letter was the existence of the easement that the applicant claims. So if you look at the correspondence that they submitted to you, I think it was a January 25th letter, they made 2 claims for an easement, which in itself is curious, because if there's a direct easement here, you don't need a second theory for an easement, which is what they proposed to you. They first said to you, we have a direct easement here. And then they quickly moved on to, and if we don't, we have an easement by Estoppel. In fact, they don't have either. And I do have the document that Mr. Heap was referring to, and I have sufficient copies, Patrick, for the board here. Wait a minute. And if you need more than
Same.
Yeah.
Can I ask you a question while this is going
Sure.
on? The easement you're talking about is the easement for the driveway that goes from Meyer Road to the 2 houses at the back?
Correct, the 50-foot wide right-of-way.
Okay. Whose property is that driveway on?
So both the successors to Lot A and Lot B each own to the midpoint of the right-of-way.
And who owns Lot A and Lot B?
I'm sorry, who owns?
Who owns Lot A and Lot B?
So Lot A, the Shamsuddins would be the successor to Lot A. They own parcel C and they own Lot 28 in the back. The McKechnies are also successors to Lot A. They live at the end of the right-of-way. And
Excuse me.
Yep.
Who owns the 2 pieces, the property
telling
that
you.
the driveway?
He's telling you.
There's
Okay.
actually more than 2 people now.
Yeah.
Okay, fine.
There's 4, I believe.
Okay.
So if you go back from Meyer Road, you have the Shamsuddins who own the property that was parcel A, which it became parcel C. The front portion became parcel C. A became C and D. D is owned by the McKechnies at the end of the right-of-way, which I think is 52 Meyer. And then you have lots B1 and B2. So the McCarthys, I believe, own B1, and then the McGuires own B2. So you have 4 owners now.
Okay, thank you.
Yep. So I don't know if that deed made its way all the way around the table yet.
Yep.
So I apologize, I didn't highlight every copy, but if you're looking for the relevant language, it's towards the bottom of the document. I don't know if you can see this. I'm happy to walk around the table so you can see it. It's this section down here.
Yep.
Okay.
See, right here on the bottom.
This,
Yes, yep. There. This section on the bottom.
Okay.
Can I, before you present this,
Sure,
has our attorney seen this?
I believe he has.
This is the deed to.
Yeah, oh, I'm sorry, Chris. I've got
It's what you were just talking about.
Yeah, this is what he was reading from.
Okay, and so just can I ask a question of our attorney? Since you've seen this document, has this changed your opinion at all?
It has not.
Okay, thank you.
So this is the document that your attorney was just reading to you. This is the language of what the applicant claims is his express easement. Okay, now, what's interesting, this is recorded at 4268167. What's interesting is if you go back and look at page 2 of the applicant's letter to you, they don't make any reference to this particular instrument. They cite a later deed, which just makes a reference to a right-of-way. They cite to 4314-102, I believe. Which is a...
So are you, I guess I'm trying to understand your interpretation of this, because I interpret this as a right-of-way.
Well, what you have to look at here is what the actual language of the deed says. And what this deed says is that the premises are conveyed together with the right-of-way over the southerly portion of that private way. So the conveyance to Lot B being the southerly portion, and the grantor retaining a right in Lot A. Right? Now, it's council's interpretation here that that's a mistake. It could have been a mistake, but you don't know that it was a mistake. This deed was executed 60-some-odd years ago. It could have also been the express intent of the parties to frame it exactly as it is. What you're left with is a document that does not grant an express easement. So what does that mean for the successors to Lot A? That they're entitled to use to the midpoint of the right-of-way only. They do not have an express easement over the other 25 feet, which includes the McGuire's property at this point. So I don't think that that point is disputed based on how your counsel just interpreted or read the document to you. There's a difference as to what's the legal interpretation of this document, what does it mean? And again, respectfully, that's for the land court or the superior court or somebody to decide. This applicant came to you asking you to approve a subdivision that incorporates land owned by somebody else. There's no dispute about that, that they acknowledge that the fee title is owned by the McGuires on the other side of the right-of-way. So in order for you to approve a subdivision plan that incorporates land of somebody else, you need their consent. You don't have their consent in this case. So I would say on that reason alone, this application has to fail. If the applicant wants to advance this theory, he needs to come back to you with evidence from a court that he actually has title to use this. So when I say that I don't think the board has the authority to make that determination here, it's because you're not presented with actual ownership of all the land that's in the subdivision. So let me move quickly on to the,
So
yes.
one quick question. So this is part of the deed for what was part of Lot A, correct?
So this is the deed, this is the
Oh.
Tremblay to Chittick deed, I think it is. So what that was, Tremblay used to own all the land.
Yep.
And if this is the first conveyance, this marries up to the 55 plan. We have A and B.
Yep. Right, but this is for A.
It's for B.
For B.
It's for B. This is the conveyance of B to the Chitticks.
Okay.
So I don't know if you have the 56 plan still in front of you.
So
Yes.
have you ever seen language like this in a deed that doesn't make sense in terms of a right-of-way and conveying the part that you already own rather than the right to own the other part?
It is certainly curious language, but again, what you're left with is what was the intent of the parties at the time that they executed this deed, and you've got no evidence as to what the intent of the parties was before you here. Again, for one reason, that you're sitting here 65 years later looking at a document that you're left to make an interpretation of, which is not your role here. Your role is to look at, does the applicant have all the property? Would this conform to our rules and regulations for subdivisions?
I guess the question would be whether, given the unusual meaning of it, and which doesn't seem real logical, whether we have to go with what seems to be a reasonable interpretation and make a decision and let the courts decide whether to stop that action.
Well, it's been presented to you that there's no other reasonable interpretation of this, that this had to mean that it was an easement. It could just as easily have been interpreted that they did not want to create the easement right or the right-of-way in the other side of the right-of-way, that they wanted to limit the 25 feet to each side. For one reason, what became parcel C has access from Meyer Road. It didn't need additional access. So again, what we presented to you in our original letter back in January was that you also have to consider what was the original intent of the right-of-way. And the original intent of the right-of-way was to provide access to these two lots, B and what became D. Yes?
So does this get back to our attorney's original supposition that this really is a title question?
I think you could frame it as a title question, yes, meaning there is a dispute as to who owns or has what rights to the property.
Right, and our attorney has just advised us that ours is not to get into deciding who has title, because that's the court's. It's in its purview. So I just want to be clear about, you know, what our attorney had, because I believe, and if I'm wrong, I'd like to know it, that he has all this information, has reviewed this information, and I'm very respectful of your point of view. I think it is a question that the title question has to be settled by land court. So our attorney has advised us that that does not fit into our area of authority. That he has looked at this and said, based on the information presented by the applicant and the arguments that you've made, that there is nothing that would prevent us from moving forward and approving this.
And I think that, I'm sorry.
No, go ahead.
Yeah. I think respectfully to Mr. Heap that advice is not correct. That what you don't have the authority to approve the subdivision. Yes.
I got it.
Yep.
I mean, we have a
right.
We're at loggerheads over, you know, what your reading is, and I can't say whether it's right or wrong, and what our attorney is advising us. So I'd like to know from our attorney, if we proceed to approve this based on your guidance, what is that? Where does that put us in terms of legal action? If you don't mind me, I just kind of like to cut to the chase, because we could be arguing back and forth on this title.
I hate to say it, but I think the practical reality is that this application is likely to result in litigation of some kind, regardless of what you do.
Right. So I want to know.
Because if you deny, you've got essentially two choices.
We're damned if we do and damned
if
we
you
don't.
If you were to deny this application on the grounds either that you don't like the road, or that, you know, there's subdivision stuff that you don't like, or that or because you've taken the abutters side of the title dispute, the applicant is certainly going to file another appeal to land court, because they believe they've got the right of it. If you were to grant the application, I have to assume that the abutters are in a position at this point to appeal your approval of the subdivision. And so either way, if I've handicapped that correctly, the title question is headed for a decision of some kind down the road, assuming that nobody, you know, the property owners can't work it out in some way between now and a final judgment. I don't know if that answers your question, but I think the answer is it's maybe bound for litigation no matter what.
And that's pretty apparent. My question is, are we a party to that? Because what I'm trying to figure out is sort of a cost benefit in making this decision. Are we a party either way?
You are a party either way, but
Okay.
there is a meaningful difference depending upon which way it goes. In the event that you were to deny the subdivision application, the applicant would file an appeal pursuant to Chapter 41, Section 81BB. That would go to land court. The board would be a defendant.
Okay.
And the board would be principally tasked with defending that lawsuit. So you would be the primary defendant, and you'd have to defend your denial of the application.
Got it.
In the event that this is ultimately approved by the planning board, it seems somewhat likely that the abutters would file an appeal of your approval of the subdivision, in which case the planning board would be a defendant, but so would be the applicant. And in cases where that is true, it is more common than not that the applicant, who is the beneficiary of a permit that you've granted, takes the lead in defending the litigation. So the title question would be raised either way, but in the event of an approval, it would be more likely that the applicant would be defending its side on the title front and the subdivision front too. I mean, they would take the lead in defending all of those issues.
Okay.
Chris, can I ask you a question too? What would prevent the Shamsuden party from building his own road on his own property?
I don't have that's more, that may be more a question for their engineer. I don't know that I'm going to be the one to answer that question.
But what I mean is, if that happened, then there would be would there be no way that the other two parties at the back of the property area would be able to sue because the road will only go to Shamsuden's property?
Abutters to the property would still have the ability to appeal the approval of the to appeal that. No, if they were to do an application, a subdivision application with the road entirely on the Shamsuden's property, nothing would prevent abutters from appealing that decision. The issues would be different because there wouldn't be this question of the title use of both sides of the private right-of-way.
Right.
But the appeal would still exist, or could
Okay.
still exist.
But would the planning board then have any exposure to that, or the same amount of exposure to that kind of a problem or suit as
No,
we
you'd
would
be-
with
you'd-
the first two? Would
You'd
that
be-
take us out of the situation?
You'd be a party to that one too.
Okay.
So my opinion is, you know, as we're kind of like between a rock and a hard place here, so no matter what our decision is, we're going to be a party to a lawsuit. So just for the, out of a desire to be efficient, I'd like to discuss other issues that might prevent us from moving forward, and then if there are none, approve it. Because it sounds like if we approve it, then Mr. Shamsuden's gonna be the lead on this as opposed to us being the defendant and the denial.
Well, can we also pass? I don't understand.
Pass.
Yeah, simply saying that there's a question of title and that it needs to be settled before we can't accept an application for a subdivision.
That in effect is a denial.
That's
Well, it
correct.
may be interpreted by us as a denial, but.
No, it would be determined by the applicant as a denial. You can't do nothing. I understand your desire to be absolved of any kind of legal action, but we can't, so.
If we point out that there is a title question.
It's still a denial.
well,
Still a denial.
But
Still a
if the
denial.
applicant making the subdivision application does not have legal rights, then we can simply deny on the grounds that
That's your
And-
opinion, that's not
and-
the opinion of our attorney.
Right.
Our
And-
attorney has advised us that we have the ability to move forward to make a decision based on other issues. So if we decide not to approve it, it's a denial. That makes us the defendant, and Mr. Shamsuden is not involved at all. So we're the lead defendant in that. I'm thinking as a strategic, cost-effective move is to look at, is there anything blocking our approval of this? And if there's not, then approve it, and then let Mr. Shamsuden take the lead in litigating this before the land court, determining who has title. As our attorney has said, we don't have a purview over title.
I agree.
That's what these attorneys are arguing over, is title. Our attorney, let me finish, our attorney is telling us we're not in the decision-making mode of title. I know the abutters are saying you can't give it to them because they don't have clear title. Our attorney is saying that's a question that has to be settled in court, not here.
And I would just add one thing. Some title questions are very simple. You either have title or you don't. You look at the chain of title, you look at the deeds, the question's answered. Easy. Some title questions are a little bit more complicated, and I think this might fall into that latter category. We have attempted, in the months that we have been working on this project, and going back even in the litigation that's been going on for the better part of a year, to look at all the title questions and attempt to come up with the best answer. And based on our review, the way we come out, I think, is the property abuts a 50-foot wide right-of-way, and it does appear, despite some quirky parts and some complications, and I want to give credit to the objection of the abutters, it does appear that the property has the benefit of the road and improving it. So I think I don't, you're not, so I just want to make clear that your decision on this isn't going to answer the question finally. That is ultimately going to be up to the land court judge. But we wouldn't, I just want to be clear, we wouldn't, I don't think, be here tonight if we hadn't looked at it and thought that the best answer on these questions is that the applicant has the right to improve the road.
So the planning board's job here is essentially whether or not the application meets the criteria of the definitive subdivision regs of the town, correct?
That is where I would have the board focus its review, yes.
Thank you.
And
Thanks, Patrick.
I agree with that 100%. You should be looking at your rules and regulations. What I wanted to say is the language that we're using to describe this question of the easement as a title question is, while technically an easement is referenced in a title, for your purposes, this is not a title question that you need to decide. This is a question of your rules and regulations. Does the applicant have the land necessary for the proposed subdivision? Does he have the easement that he claims he has, which your rules and regulations required him to put in his application? There was a statement in the application that makes reference to an easement over the right-of-way. What your counsel's told you is that the face of the instrument does not establish that easement. The only way that you get there is if you make this interpretation, okay, which he's made, if you're adopting his interpretation. So I did have a conversation with Mr. Heap about these issues. I haven't had the benefit of seeing his response letter to my letter, so I'm a bit in the dark on what all of those arguments are. But I think you need to be very careful about how you are approaching this for another reason, because everybody knows that there is other litigation here going on, and that there have been settlement discussions in that litigation. So to make a decision based on what you think the ease of the litigation burden going forward might be, I would suggest is not an appropriate basis for you to make a determination. And Mr. Heap, I'm sure, will counsel you regarding of when costs are appropriate and when they might not be in situations like this. But I think that what you need to look at is what is the right thing to do in this situation based on what your rules and regulations tell you. So it is undisputed, it sounds to me like there's no express easement. And based on you can look at the language in front of you, we're not disputing which one is northerly and which one is southerly and what the actual deed says. Again, it was curious that the applicant didn't make reference to that instrument, because I think that they agree that they have a problem with their express easement representation. Now, they made a claim to you about easement by estoppel. Let me just go quickly through what an easement by estoppel here. It doesn't apply to this situation. It is an extremely narrow doctrine in Massachusetts. It basically prevents a grantor from denying the existence of a right-of-way when there is a property bounded by a way and there's a plan that's recorded with the deed. The problem here for the applicant is that the applicant was the grantor. It's the grantor that gets estopped from denying an easement, not the grantee. Okay, it's the grantee that would be able to invoke the doctrine against the grantor, not the other way around, which is what they're trying to do here. The other thing is that this parcel is not bounded by a way. If you look at the instrument, you can see that all the bounds refer to other parcels of land that surround it. It's not like you know, just Meyer Road is a boundary or something like that. You've got references to other pieces of land. So you don't have a direct easement, express easement. You do not have easement by Estoppel here. This is not an as-of-right subdivision plan. There are multiple waivers that are being requested of you. You are perfectly within your authority to deny this plan. You have no consent to the use of the abutters' properties by the abutters. And with respect to the modification argument, you don't have a request for a modification under 81W in front of you. You just have this proposed subdivision plan. Nobody's gone back to actually try to modify those previous plans. We disagree with council's interpretation that consent would not be required. Consent would be required from the abutters in this case because those conditions that were on those other plans are able to be relied on. And actually the case that I cited in my letter to you from January, the Matthews versus Planning Board case, actually addresses this point in a footnote that that's at 72 Mass App Court 456, and at 464 at footnote 9, it mentions that lot owners were entitled to rely on the enforcement of notes in the recorded subdivision plans and recorded covenant. So you have the same situation here. You have recorded restrictions that these parties should be able to rely on, and they can rely on it. So you'd need consent either for the use of the land or for a modification, which is lacking here. So again, you should look at this proposal on its merits. I know that there's other litigation that is going on with Mr. Shamsuddin for the A&R plan. This is likely to result in litigation, how you decide this. That doesn't mean you should shift the burden in this case to the abutters rather than the applicant who's asking you for a subdivision plan. If he doesn't have the land and he needs the consent, he's got to go establish that. You don't have to make that decision for him. You shouldn't look at outside considerations to motivate you. You should look at this on the merits of the plan. It's lacking in several ways. I haven't even gotten into the restrictions. I understand you have a heavy agenda tonight, and you probably don't want to spend too much more time on this. So I don't think I need to go through point by point of Mr. Heap's presentation. He agreed with me pretty much on all the facts that were presented. We vary in our interpretations. I would submit to you respectfully that the arguments here, the legal issues are serious, and that there are multiple flaws in this application, and you ought to deny it. You should not sweep these objections under the rug.
Thank you.
I don't know if anybody has questions after that.
Questions? No. Any other comments from?
Can I make a comment first? When I stopped you and asked you to get closer to the answer that I wanted, it was because you had used the word that I didn't realize, and didn't realize that was saying I'm answering your question. I'm basically apologizing for jumping in.
Oh, you don't have to apologize. You're a board member.
Yeah, but if I don't know what's going on, if I make a mistake, I'll apologize.
Thank you.
You're welcome.
Be very brief.
Sure.
Suffice it to say, I, with all due respect, disagree with what Mr. Pasquarello has told you. We do have the right to use.
Could you introduce yourself?
Sure. I'm Peter Nectum again. I'm from McLean, Holloway, Doherty, and Sheehan. I'm representing the Shamsuddins. We certainly have the right to use the entire width of the private way because of an easement by Estoppel. And I've laid that out in my memo. That's part of the record. That position is supported by your town council. Also disagree with Mr. Pasquarello regarding the argument that we don't have an express easement. There's really only one way to interpret that document, which I didn't see, but I assume it is the initial deed from Tremblay's, the common grantor of all of this land, to Chittick, the first deed out. So in that initial deed, Tremblay made a mistake in the description of the right-of-way, as you've heard. It's actually the second mistake that Tremblay made with regard to that conveyance. The first one was he forgot to include the right-of-way at all in the first deed out to Chittick. I actually so you can make it easy, see what I'm talking about here, Mr. Reffett. I've got a number of copies. I'll just give them to you, just so you can put them in the record. So he left it out of the first document you'll see is the first deed from Tremblay to Chittick, when he left the right-of-way out completely. Then tried to cure it by filing a confirmatory deed. And he did include the conveyance of the right-of-way in that deed, and that's the second document in that packet. It does have a scrivener's error in it. Read literally, Tremblay is granting to Chittick a right-of-way over the portion of the private way that he was conveying the Chittick in fee. Makes no sense. He got it backwards. But it's clear what the intent was, to grant a right-of-way over the opposite portion of that private way, portion that the grantee, Chittick, was not getting in fee. And Tremblay wanted to retain for himself a right-of-way over the portion of the private way that he was conveying to the grantee, so that the grantor and the grantee, they both had a right-of-way to use the entire width of that private way. I mean, that's really the only way that conveyance makes sense. And I'm confident that if we ever have to present this to a land court judge to reform that, I think there's really only one way that can be interpreted. Just wanted to make that clear for you, that's our position on that. I think it got a little cloudy. Again, I know you want to move this matter along, but I do hope you consider what the current situation of that private way is right now, and what the Shamsudans are proposing to do in terms of improving it. I mean, we're improving it in a way that satisfies the fire department, and it's actually 6 feet, we're making it 6 feet wider than Meyer Road, the public way it goes to. So I hope that you consider that in making your decision. If there's anything else, I'm happy to address it now.
Yes, sir.
One response point, sorry. Just one point in response to Mr. Nectum. You know this is not the first time this matter's been before the Hamilton Planning Board. In fact, and it's not the first time town council has advised the planning board. A previous town council has weighed in on this same issue many years ago and commented on the language of the deeds, which said it may have been a mistake, but what you're left with is what the actual language of the instrument says. So, and what the actual language of the instrument says is passage over northerly, southerly, and how they line up.
So I'll be brief, I promise. Brett McKechnie, one of the abutters, 52 Meyer Road. So if there's all this interpretation going on around that document, it could just as easily have been mistaken that says does not have access as opposed to does. I mean, it says what it says is really what I'm trying to say. Secondly, there was a comment made about the lack of impacting an abutter from the house, the property or the house that's behind, so they don't have to be concerned with that. But what I want to bring up is all of this goes through, and there's going to be signs on the right-of-way or on part of the right-of-way that I have access to use. And if this gets approved right with that hammerhead turnaround, that's going to deny me the access to be able to use that right-of-way. If I want to pave it, if I want to do anything else to it, I should be able to. But as soon as you put that there, you've now denied me using that right-of-way. Right here. So the right-of-way goes right across here, and by putting no parking here, I will not have access to do that if I want to pave it or put a driveway in or put a fence up or anything else that I want to. So I just want to make sure you guys consider that right there, because that is literally in my front yard. The last thing that I would say is, again, with as part of the original subdivision, this private way did not even exist. The only way that this was able to exist with this lot here and the lot that we live in is because it says only one house on each lot. Without that, the original planning board would not even have accepted it. So I do ask that you abide by, the decisions that they made, and, we're obviously negatively impacted. If I want to fix the driveway, which I certainly can, Nazir should be part of paying for that, but that doesn't give him the right to just put 3 houses on that driveway.
I don't get that. Besides
Which part?
Well, if you're saying he has rights to use it and
Yeah.
do this.
What's
why
that?
wouldn't you saying, you just said he has rights to use it, and.
No, I didn't say he had the right to
Yeah,
use
yeah,
it.
you did.
No. I said if he wants to pay, he doesn't have the right to use it. But if he wants to if I want to use it and put a driveway, improve the driveway, I can. That's up to me.
But the problem is that none of this seems relevant to what the real problem is.
There's a lot of problems.
I think, go ahead, Rick.
So I'd like to sort of call the question, because we could go around and around.
Yeah, no, I'm good.
think
I just
so,
wanted
too. I
to-
think this is
No,
really
I actually appreciate your comments. I'm not trying to shut you off. This is a fascinating legal question, and I'm actually glad that you're taking the time and spending the money to bring it to our attention. Everybody thinks working on the planning board is really dull and doesn't require any, discerning. Yeah. So I think it's fascinating. So for me, this really gets down to strategy, and this isn't about making a decision. Both attorneys have agreed. This is going to end up in land court because the title is not clear. So if we deny it, it's going to land up in, and we're going to be the primary defendant. If we approve it, then Shamsuddin and the planning board are going to be defendants.
Well, and the other part of it, I kind of disagree with what you said earlier about, using that strategy.
Okay.
I mean, I lean more towards, our town council, right?
Oh, well,
What they say,
yeah.
right, and what they think and how they interpret it. They're the ones
absolutely.
that will be defending it.
So I guess what I want to say is that I want you guys to do the right thing, not because of, if there's other lawsuits going on, or it's going to be more economical, or whatever all that is.
Right.
Make the right decision.
Right. No,
Obviously, from our side, it's clear. From the other side, it's clear. You guys have to make the right decision and go from there.
I disagree with that. I don't think any of it's clear. And if I lived there where you live, and this man was going to give me a driveway that made it safer from my property and everything else, boy, I'd be jumping all over that.
Well, let's not get into that.
You're right.
argument.
That's a
It's
minor
not
issue to this whole thing.
Yeah, it is, and so I'd like
So-
to continue the discussion.
You're right. It doesn't belong
I agree with
there.
you. I wouldn't have gotten to that recommendation of strategy, because the last time this board ignored its town council, we ended up in federal court and ran up a legal bill for $100,000 and lost the case. And when we knew we were going to lose it, because our town attorney told us we were going to lose it. So I do not want to make that same mistake again. So I agree, we ought to abide by our attorney's recommendation that there are some key issues here that need to be resolved by court, but they don't prevent us from ruling favorably on this application.
Right, if we all think, or the majority of us think that just looking at the subdivision itself.
Yep.
That it meets, what
Yep.
we need it to meet, basically, is what it gets down to. What are your thoughts, Peter?
No, I agree. If we put our blinders on and don't look at the title issue, and all we do is say, does it conform to subdivision bylaw? I believe it has been, and it's been engineered by our favorite engineer. He's always in front of this group, so he's not making mistakes. It's the bylaw, so I would agree with that.
You have any comment, Ted?
I agree.
Agreed.
So it sounds like we've got a unanimous agreement.
So we should have a motion?
Rick, you're shepherding this thing.
No, what I'm trying to do is get to the core issues.
Yeah.
And,
And I think that is the core issue.
so I've got to go back to the,
I
just have to tell you, I disagree. I just think that making the decision
Well,
based
you got to
on-
introduce yourself, please. I'm sorry.
Yeah,
Susan Lawrence, 105 Rock Maple, sorry. I just need to say that I disagree. Making a recommendation based on the economics of something doesn't seem to be.
Not what we're
Not
doing,
what
though.
we're doing.
Well, it sounds
I
that
basically
way.
said that's not what we wanted to do. That I disagreed with him on that. But we want to go with. I think we need to go with our town council's opinion, not based on economics, but just for that opinion.
Compliance with the bylaw.
Well, it doesn't seem to me that we have the information to go ahead and approve something.
I mean, again,
You're absolutely right.
I in a sense agree with a portion of that, but
Information to go ahead and approve something.
Well, we've actually listened to both parties. Our town council is recommending that we have the ability to move forward, to make a favorable decision, that the title question needs to be litigated or will be litigated one way or another. So we are, as I said before, we are between a rock and a hard place. We can deny it, then we become the sole defendant in a case.
but again, I don't think that's relevant, though.
No, I understand, but it is. It is relevant because our town attorney has told us what his recommendation is and what the consequences are if we ignore his recommendation. So I think it is relevant, but anyway.
I guess the way I would characterize it, after having gone through all this discussion, is that this is to acknowledge that this application presents some difficult questions of title and rights in the private right-of-way, but that based on our best effort to determine whether or not this applicant has the right to develop the road as proposed within the bounds of the 50-foot wide private right-of-way, that it is our best the best conclusion we can arrive at is that the applicant has that right, and that is the way we would suggest that the board proceed. So again, I don't want to diminish the number of arguments presented tonight or the difficulty of them, but our best attempt to come to the right conclusion suggests that this applicant has the right to use the road.
I assume you are disclosing your town council's opinion letter to you, since you
public
are obviously,
It's public information.
okay, it hasn't been disclosed yet.
Right, it hasn't been disclosed.
Right, so the public is in the dark as to, other than Mr. Heap's recommendation here, we haven't seen any of his legal reasoning. We don't know what the actual opinion letter is. So I would suggest that needs to be disclosed. And again, with respect to who the party is in this the litigation that you think might happen here, the board, no matter what your decision is, the board is always the defendant of an appeal. So whether you have a developer riding along with you, whether you have a neighbor that might intervene in litigation that is brought by a developer, those are things that you should keep into your consideration. However, what I would again submit to you is that you need to look at whether you actually have the authority to make this decision and whether the application complies with your rules and regulations. And it troubles me that it seems like this conversation is going in a very different direction than that core question here.
I disagree. I think we've been told by our council that we do. That's
No,
what
you were told by your counsel that there is the language of the easement document that's presented to you doesn't establish an express easement, but it's his interpretation that a court might rule favorably
That's
that
right.
way.
That's right. We
Right,
accept
yes,
that.
and what I would suggest to you is that alone would require you to deny this application, because that is an admission that right now, before a court decides this, the applicant doesn't have easement rights in the right-of-way. End of story. That's the simplest way for you to decide this. Come back to us and make an application when you can prove you have easement rights. He hasn't done that. And if you make the decision to approve this, you are, respectfully, you're exceeding the authority of the board.
Well, that's what the court will determine if in fact we approve this. So I'm very appreciative of the fine argument you have made and the passion with which you have made it. But this is going to be a legally adjudicated question. And so the question before us is, does it comply with our subdivision rules and regs? Our attorney has advised us there's nothing to prevent us from considering applying those standards to this, and that's the direction we're headed with this, at least for now, and I think we have a consensus on the board that that's our preferred approach. So you have a different opinion, our the town's attorney has a different opinion, and those will be resolved in court. So God bless our legal system.
I know you need to come to a decision. But the last thing I would say is, because you think that litigation is likely on both sides, is not an appropriate basis to make this decision. And punting it to a court and saying it's okay if we make this decision either way because somebody's going to appeal it.
I don't agree with that interpretation of what we're doing. We're making it on the basis.
I'm not saying that. What I'm saying is that you want to be careful that that's not what you're doing.
No, we're doing it on the basis of the subdivision regulations.
We are doing it on the basis of our recommendation by the town attorney that there's nothing that prevents us from moving forward to apply the subdivision regulations in this case.
Yes, but you're also doing that in the face of direct countervailing evidence to the contrary. So,
and we are, and that evidence is disputed evidence, and our town attorney is recommending that we have no need.
No, it's actually, it's not.
We don't need to keep.
I know we don't need to keep arguing this.
We get it. We get it.
Thank you.
We get it.
But I want to ask Janelle, the question, if the applicant doesn't have legal right to the right-of-way because of the questions of title,
I think
we're substituting the reasoning of the town's attorney that, oh, it must have been a mistake. And that's where I think you could just as easily deny the subdivision on the grounds that there are no legal rights to the full right-of-way, land under the right-of-way.
Go ahead. I don't think that's exactly what you said, but.
No.
Yeah, be brief, please.
I'll be super brief. The 50-foot wide private right-of-way has been shown on a plan that's been used since 1955 and has been used to convey lots on either side ever since. The person who laid out the 50-foot wide, the people who laid out the 50-foot wide private way originally on the subdivision plan are the couple who sold parcel A, B, to the abutter's predecessor in title, in the deed that we've been talking about all evening. So they laid out the road and then conveyed out property on the other side of the road, I think with the clear understanding that people were going to be using that road on both sides for the remainder of the use of this property. I think that was a general description that was attempting to avoid the finer points of all these deeds and all these plans and the minor screw-ups. The road's been there for a long time, and I don't want to diminish anybody's arguments, but it's been in existence for a great long time.
Right. And again, you don't think there's anything, in your opinion, to prevent us from making a decision?
I think that where the applicant. It is my belief that based on review of all the deeds and all the plans, that the applicant owns property bounded by a 50-foot wide private right-of-way, and that where you own property, this is just devolving to the most general of rules here. When you own property bounded on a private right-of-way, you have the right to develop that road for its full length and width, and that's essentially what we're talking about here.
Okay.
So that was a long-winded way of saying. We've looked at it very carefully, and there are difficult questions on either side, but it is our best conclusion that the applicant has the right to improve the roadway as they have proposed to do in the subdivision application.
So excuse me for a second. So given that we are working within the bounds and mets of the zoning bylaws, that that is the grounds upon which we would be valid in approving the request. Is that correct?
I think ultimately the question is whether the road is one that provides
Yeah. Okay. Fine.
access to the lots that are
Jen, real quick, please.
Jen McGuire, 54 Meyer Road. Just a question probably for you, Chris. So in doing this and putting 2 new homes on the driveway, how does that work with the easement? Are you requiring us to then grant an easement to these 2 new property owners?
You got to come, please.
Applying everything that I've just said, those other 2 lots already have it. The easement runs to the land, not to the lots themselves. So it would apply, the easement would cover everything within the bounds of what was once shown as parcel C on the old plan, not necessarily to lots, well, and by default to 1, 2, and 3 if the plan is ultimately approved.
And one of the other things that I, in just doing my own research, kept reading about was overburdening an easement, and where it looked like the initial intent of the easement was really to access those 2 properties. I just don't understand how this wouldn't be considered an overburdening.
And on that point, the subdivision parcel is made up of 2 different old lots. One is parcel C and one is lot 28. Lot 28 is the part that is behind parcel C, which is back. So lot 28 is up here. Parcel C is this part here. Parcel C abuts the right-of-way, and I believe has the right to use it for its full length and width. That is not true, I don't believe, of lot 28, but lot 28 can be added to parcel C as part of the development parcel, provided that there's no structures put on what was once lot 28. And I would suggest that probably needs to be a condition of an approval, but again, as long as all the structures on the development parcel are on what currently exists as parcel C, I think that is okay, and not an overburdening of the easement.
What was the, could you go back, Chris? What was the condition you recommended?
That as part of the any approval, that any residential structures being built on new lots 1, 2, and 3 would need to be placed within the bounds of parcel C as shown on the 1956 subdivision plan.
Could you write that out, please?
Yep.
Is there anything else that we want to consider as a condition on this?
That it remain private.
Can I really quickly just say something about this? There's already 3 houses on that lot. And now you're gonna put 6 houses that are attached to that lot 28 that's only supposed to have 1 dwelling. But now you're putting a restriction on the new lots, but it doesn't apply to the old lots. I just don't understand that, that's all.
Thanks. So what did you say, Rick? Sorry.
My question was, were there other conditions that we think are appropriate to apply?
I mean, we don't see any additional screening or anything. That's my
No,
question.
because we talked about the roadway, which was the primary issue.
Right.
And the fire, life safety issues.
Yeah, right. The fire department's okay. Any conditions you want to put on it other than what we talked about?
No, just get the court.
Do you have any that you want to
Clear
do?
up the title issue.
Janelle, you good? Any conditions?
Good.
Okay. So we've got that condition Chris just mentioned. What else? Is there anything else we need to do, Patrick?
That it remain a private way?
That it-
Well, remain private, yeah.
Right.
Yeah.
That's implicit, right. I think that's it.
Okay.
As per plan.
Right. And what's the, just need the date on that. What's the,
Yeah, I don't have that.
hey, Bob, what's the latest date?
These plans are dated February 11th.
211?
Yep.
Do you have the language, or are you still working on it? All right. I'm ready. You ready?
Yep.
Okay, I make a motion that the planning board approve the definitive subdivision application of Nazir Shamsudin with the following condition, based on the plans submitted and dated February 11th, 2019, with the following two conditions. 1, it remain a private road. 2, any structures shall be contained wholly within the bounds of parcel C as shown on a plan of land entitled Plan of Land belonging to Noah A. and Ethel M. Tremblay dated 1956 and recorded at Essex Registry of Deeds, Plan B.K. Plan Book 1956, Plan 704.
Second.
Any further discussion? All those in favor?
Aye.
Aye. Opposed? Unanimous?
The vote to close the hearing.
Oh. Yeah.
I make a motion to close the hearing of the definitive subdivision application of Nazir Shamsudin.
Second.
Second. All those in favor?
Aye.
Aye. Opposed?
Can't believe what you guys just did. 15 years I've spent building this place up. Thanks. Sleep well tonight.
What was his parting remark? What's that? What was his parting remark?
What's that coming?
He's upstairs.
I'm not sure.
Brian, can we take a short break, please?
Sorry?
May we take a short break? Or can I just,
If you have to, but I'd rather just.
okay,
continue.
just keep going.
Okay,
I've
all
got
right,
to.
that's fine.
I'll let him go
We'll
first.
take a couple minutes.
I want to get some water.
Yeah.
You think they will go on court on title? See, we.
You're on the
from the show that, oh, they're gonna lose in court now.
It's okay.
I don't know. I mean, that's a good question.
But for our town council to sort of say, well, it really meant to be the opposite, that really threw me for a loop.
Well,
That's a
I mean,
conjecture that
it makes it. Really look at it logically. I think it makes sense. And it is interesting, the whole, I didn't notice the dates of those two deeds were the exact same day, and they were.
Yeah. Oh, man. Thank you.
Thanks.
Drive it to the city. Nobody's going to be there.
Sure gonna mess up the.
I'm gonna crash your party.
The town's beautiful property. They don't show what the building's gonna look like though.
Well, they have elevations.
This one?
Yeah, there they go. Well, those are, no, I haven't seen those yet. They have elevations in the setting. A while back.
I think it's
Big.
and will all the odors.
Well, that's what we gotta figure out. We can't answer that one. That's why our engineer will do it.
Mm-hmm.
Either way, we end up in court. One word, the primary and only defendant. Is the primary defendant, because it's his interest. So it's like, you go figure it out.
Patrick, do you want us to start now, or do you want us to wait?
Mr. Chair? Yeah, we've got person out.
War office down there.
I'll go out later, so.
All righty.
Please.
I need to read this, right?
Oh, yeah, I'm sorry, we have to read this into the record, and then you can go.
Okay. Notice of public hearing. On April 2nd, 2019, in Hamilton Town Hall Memorial Room, 577 Bay Road, the Hamilton Planning Board will hold 2 related public hearings concurrently. And the first one we've already done. The second is proposals for medical marijuana cultivation and processing facility to be located at Green Meadow Farms. The location is 654 Asbury Street, and also known as Assessor's Map 19, Lot 4, and is zoned RA. The applicant proposes to operate a medical marijuana cultivation and production facility in the proposed 65,800 square foot building with appropriate site improvements to accommodate the use. The site plan will be in accordance with Section 10.6 of the Hamilton zoning bylaw and will also include additional host community agreement conditions as previously approved by the Hamilton Board of Selectmen on August 20th, 2018 for the facility. The hearing and review also includes a special permit, the Hamilton Planning Board, which is in accordance with the Town of Hamilton General Bylaws, Chapter 29, Stormwater Management. Copies of the application and materials are available for viewing at the Hamilton Planning Office and Building Department during regular town hall business hours. Any person interested in or wishing to be heard should appear at the time and place designated.
Thank you. Please proceed.
Hi, I'm Bob Patton. I'm CEO of Green Meadows Farm, the applicant this evening at 654 Asbury Street. Very quickly, I just want to thank you all for the invitation to present our project and our greenhouse siting project to you all. I want to very quickly introduce some of the team that are here. They'll be available to answer questions as we go through, and as you all see if they come up. We've got, first of all, leading is the discussion tonight will be Kevin McGarry, our project manager at Fuss & O'Neill Engineering. This is Chris Sawaki, our COO of Green Meadows, also my stepson. And then we have our general contractors, Sean and Roxanne Costello, Essex-based, very well known in the area. Not all of our team, but certainly a major component. And also behind, we've got Benjamin Bork in the green shirt there is our Director of Cultivation, has been with us for a while. An essential element of what we're trying to do, an organic disciple, an organic believer through and through. We're thrilled to have him, and also his family. He's a botany-trained scientist out of LSU. His family, his wife and 3 kids, will be coming east, we hope, to join us when the school year's out. They're based in Denver right now. So quickly, before I pass it on to the people who know what they're talking about in this realm of this application, it was February of 18 that we originally presented to the Board of Selectmen and presented our ideas of the Patton family of what we wanted to try to do. At that time, knowing me, I probably thought I knew more than I did. It's been a long time since. We've learned a great deal. I'm still on a steep learning curve, but trying to get there. In that period, we spoke a lot about intangibles that I think are tangible, but I think you'll know what I mean. We talked about our belief of trying to be an organic farm, as we have been for many years on this property, to be a community resource, to be a great neighbor, to be an employer, a taxpayer, a financial partner. That's a great deal, an aspect of what we're doing. And we're very proud of those things on those bases. Now as we go into the physical siting, I've come to understand, and meeting so many people that are also cultivators in New England and around the country, and I always circle back to one word, and I say, what was it like going through the process? And they say, remember one word, agriculture. You're doing agriculture. And as we look at this element of this project, that's how I look at it. I imagine that's in this realm where it will be looked at as well, an agricultural facility. As proud as I was of all those intangibles that I think we're going to be for the town, I'm as proud of this structure and the team that put it together. So I really present with the people, again, in the know, to them, to you, to say that we, the family, our partners, bring it to you with pride. Thanks.
Thank you, Bob. For the record, my name is Kevin McGarry. I'm a licensed professional engineer in the Commonwealth of Massachusetts. I'm a project manager at Fuss & O'Neill here tonight representing the applicant. So as Bob mentioned, I think one of the most important things that we've focused on as the design team at the direction from Green Meadows is to do the right thing. Green Meadows has placed a huge emphasis on wanting to be a good neighbor and a community partner, and we really feel that the plan that we've put together reflects that. The renderings that you're going to see up on the screen and that I've passed out, just for context, these are the site plans that we submitted as part of the application package. We've just added some color to them, just to aid in the presentation. As I go through, I'll point out different things. But everything that you're seeing here is essentially was included in the application. The only, I don't even want to call it new information, is just the color that's been added. So as a point of clarification, as you said in your opening there, we are here for site plan review and a stormwater management permit. Due to the site's proximity located in the groundwater protection overlay district, we'll be also presenting to the Zoning Board of Appeals tomorrow night due to that location. To date, we've had a preliminary meeting with planning. We met here on January 30th. We had a preliminary meeting with DPW, police, and fire, and that was on February 13th. And the team also met with some of the neighbors from the Patton Ridge neighborhood and the Patton Homestead Board on March 21st. I do want to point out that during the meeting with some of the Patton Ridge neighbors, they had requested some additional landscaping and screening be added in the southwest corner, which is over here.
You want to use a pointer?
Oh, yes, I do. I'm not going to get charged extra for that.
No. Doesn't mean you win, just means you point.
I'm just going to redo that point. In the southwest corner here, we'll be adding those screenings to our next, whatever we resubmit once we receive all our comments. They're just not reflected on the plans of yet because that request came after we had submitted. Can you go to the next plan, please? Thank you. So again, this is our index plan sheet CI-001. It's right out of our site plan set. So I just want to get everybody orientated. So on all the plans you're going to see, there should be a north arrow. So north is to the right in general. So just so everybody's orientated, Asbury Street is generally on the bottom of the page on every plan that you'll see. The existing property is 20.3 acres and as previously mentioned is identified as Lot 4 on Assessor's Map number 19. Our property is bounded by the Hamilton-Topsfield line, which runs like this. And that is on the northern side of our property, as mentioned. Asbury Street is to the east. Residential and town-owned land, including the Patton Homestead, is to the south, this direction. And then the Ipswich River is located to the east. The site is located in the residential agriculture district, as well as I mentioned in the groundwater protection overlay district. The eastern portion of the property, which is where we're proposing the project, has been historically used as an organic working farm and contained agricultural fields, greenhouses, garages, and a farm stand. I want to just point out, later in the presentation, we're going to specifically talk about the evolution of the project and how we arrived to where it is, so I will get to that. There are two residential buildings that exist on the southern portion of the site. So there's a building here, and then there's a building here. There is a wetland area. In addition to the Ipswich River wetland area, there's a wetland area closer to our site, which is located here. That wetland also contains a National Heritage and Endangered Species Program priority habitat area. However, our limit of work is completely outside of that priority habitat area. The site also does contain, as I mentioned, the Ipswich River, and there is a riverfront area associated with that. But again, we are well outside those areas. There's also floodplain associated with the Ipswich River located behind the site. So that's all back in this area back here. But our limit of work is completely outside those areas. And historically, the site has been used as an organic working farm. That consisted of agricultural equipment, so dump trucks, delivery trucks, tractors, and other agricultural equipment. And there was also a crop share program that existed on the site that had over 200 members, was open 7 days a week, and had both nighttime and weekend events. Next slide, please.
Could you just go back to that one?
Sure.
And identify the square, which is
this big square?
yeah, and
sure.
What is that demarking, and then the rectangle what's the difference between those?
So these are just like, it's our key plan as part of our site plan set. So we had this index plan, and then our overall plan sort of show this big overall view.
Yeah.
And then we had 3 detailed sheets.
Yeah.
It's 101, 102, and 103. So as you flip through our full site plan, this is sheet on 100, and then it's 101, 102, and 103.
Okay.
So it's not an engineering
So it doesn't
thing,
have a
it's just-
functional definition as such?
Correct.
Okay.
It's just to sort of give context as to what the site plans look
All
like.
right.
Does that answer your question?
Well, I wondered if it was a land use category or something, but it's not.
That's correct. Any other questions? All right. The next slide, please. So again, this is that the bigger rectangle, right? Again, north is to the right, Asbury Street is on the bottom. So the project consists, the square footage of the greenhouse is actually 65,735 square feet. The eastern portion of the greenhouse structure, which is this area here, that is what will be utilized for the cultivation and agricultural grow. The western portion of the greenhouse will be used for processing and administrative support. The building is set back from Asbury Street. The northeast corner, which is this corner here, is 84 feet from the property line and 102 feet from the edge of the road. The southeast corner, which is this corner here, is 113 feet from the property line and 130 feet from the edge of the road. Just for context, in this zone, the setback is 25 feet from the property line. So again, the setback is 25 feet, but our corners are 84 and 113 feet respectively. It is a single-story structure, excuse me, that is 14 foot 3 inches tall at the eaves and 24 feet 6 inches tall at the peak. The site access will be provided in the same location that it is today along Asbury Street, and that's located right here. This has historically accommodated both emergency vehicles as well as delivery vehicles for the organic working farm. At the request of the fire chief in one of the preliminary meetings we had, he did request that we widen the driveway, and that's currently what we are showing. It will require us to reconstruct a small portion of that stone wall in the vicinity of the entrance, but aside from that minor change, there will be no other modifications to the streetscape along Asbury Street. Currently, there's an existing internal access that sort of connects this side of the existing site with this side of the existing site by a paved driveway in this approximate location. That will be removed as part of this project, so this driveway will now be for the facility, whereas the existing driveway, there's another existing driveway over here. This will remain for the 2 residential properties, or residential, not properties, excuse me, residential structures. Other site features, we have a parking lot, 57 space parking lot proposed here, just north of the building. We calculated, excuse me, the required number of parking spaces utilizing the Institute of Transportation Engineers parking generation. Based on the total square footage of the building, 54 spaces were required. Based on the anticipated number of employees, which is to be 50 spread out over several shifts, 51 spaces were required, and again, we're proposing 57. So we are exceeding the number of required spaces slightly. Other site improvements include new landscaping and screening, which I'm going to talk about in more detail. There's a small outdoor patio area located here near the main entrance. The loading dock is located on the western side of the building, on the back of the building from Asbury Street, along with our other mechanical equipment, which I'll get into a little more detail on later. And there's also new utilities and stormwater infrastructure. Jumping the gun on me. And any questions on those improvements thus far while I grab a drink of water? Yes, Patrick.
One of the things that I typically find planning boards want to do that I think is important, particularly on a site like this, is to try to limit the amount of impervious pavement to the extent possible. So with that in mind, you've already talked about the parking generation, parking requirements, that sort of thing. Can you tell us a little bit about the
Sure.
truck maneuvering in back? It looks to me like there may be a little bit more pavement there than what is absolutely necessary.
Sure. So we talked about the parking lot that's located here. The driveway here, there's an entrance off the driveway to the parking lot, and then the driveway does continue back. This large paved area in the back is here to accommodate larger delivery trucks. Those are expected to be much more infrequent, obviously, than employees arriving to the site. But the site was designed to accommodate larger tractor-trailer trucks for those infrequent deliveries. We'd be happy to provide the board with the turning templates
That'd be useful.
that were generated. But yes, we also don't want any more pavement than we need either. Any other questions?
Yes, following Patrick's lead, the roof is also a large impervious surface.
That's correct.
I question not only what you're going to do with that impervious surface, but also what's the color arrangement going to be? White, black? Is it reflective? Is it sending heat
Sure.
back upstairs, or is it going to
Sure.
take it down?
So
Keep in mind, every flat, more or less flat roof south of the Mason-Dixon line is now white. I'm curious as to what your thoughts on this matter would be.
Sure.
Not necessarily tonight, just in general.
So I will answer the stormwater question later on in the presentation. In general, these are greenhouse structures. They're peaked and they kind of run in this direction. There's 7 of them stacked on each other. The southern portion of the greenhouse where there will be cultivation, it's a translucent polycarbonate roof. On the eastern portion of the greenhouse, not the southern portion, the eastern portion. The western portion, it's the same type of roof, the same peaks. It's just a solid corrugated metal roof. I believe the final color has not been selected, but it's intended to be a lighter color. If you go to the next slide for me. These are actually some site renderings I'm going to talk about in more detail, but you can sort of see this is the proposed building, and you can sort of see just in context what our vision was for what the building would look like. And these renderings are included in the handouts that I passed out in case you can't see them.
The reason I bring up the color today is becoming more of an ethereal concentration on what do we do with our excess heat. And in this place, you might have a big cooling problem here also, which I'm sure you're addressing.
Yes.
But fine.
All right, so screening. So as a design team, we've spent a lot of time talking about screening. So I'm gonna show you 2 different views. So this one is looking south, so it's from the north, as if you were standing in Topsfield looking towards the site. And then the next one will just be on the other side of the road looking in the other direction. On each one of these views, there's 3 pictures. The picture on the top is what you see today. The middle picture is what the proposed building would look like without any screening. The lower picture is what the site will look like with the proposed screening. So as you can see, the plantings that we're proposing here in the bottom portion of the bottom picture screen the project as drivers come down Asbury Street. And then if you also go to the next slide, please. Again, this is from the south. What you don't see on the picture is just off the screen over here is a larger vegetated area. This is sort of the first time when you're coming from the south, so heading in the northbound direction, that you can really even see anything. Again, the existing view that you would see is the existing agricultural structures. The proposed view, very similar agricultural structures. We also see, it's a little tough to see on the presentation, but I think you can see it in your handouts. We have the proposed screening. There's also a wood picket fence that we're proposing that'll run down both the existing driveway and the new driveway and run parallel to the stone wall. Split rail fence, wood split rail fence. I don't know what I say. Picket fence. No, not a picket fence. Wood split rail fence. Thank you. I was testing to make sure the rest of the team was still listening. And we feel that this really is in concert and with the natural character of the other sites around on Asbury Street. Other plantings are proposed throughout the site, so there's plantings proposed inside the parking lot and along the access road. Again, those are shown on the landscaping plan that was submitted as part of the site plan application. Any questions? Okay, go to the next slide, please. All right, so next thing we want to talk about is just sort of how the project evolved. So again, this is just an aerial image. Again, north is to the right. This is Asbury Street here. Ipswich River is here. This is the you can see existing in the front portion of the site. You have the greenhouse buildings, the farmhouse, some older sheds and barns. When we first started looking at the project, we did investigate placing the facility and its infrastructure in the back of the site. But what you can see on this map is this lighter green line here is the wetland and the high water mark of the Ipswich River. And then the magenta, the red, and the yellow are the wetland setback lines, the yellow being the 100, red being 75, magenta being the 50. And then this blue line here is the 200-foot riverfront area from the Ipswich River. You can also see the wetlands over here, again, magenta, red, yellow lines. The lighter green line that you see here and here, those are just
Oh, I don't want to interrupt you. I just, at some point, show us the Topsfield Hamilton jurisdictional line.
So the town, this is the town line located right here.
Great, thank you.
This is Topsfield, this is Hamilton.
Thank you.
The green line is existing wooded areas, and when we started looking at it and we developed this graphic, it really shows you all of the environmental constraints that exist in that back portion of the property. So the things we took into consideration, again, were the proximity to the Ipswich River, its associated wetlands, wetland buffers, the riverfront area, and the floodplain, as well as the existing wooded areas. The front area had been previously disturbed. There were already large amounts of impervious areas, and it's located much farther away from these environmentally sensitive areas. And as Bob had mentioned in the beginning, you know, one of the main goals of this project is to have an environmentally friendly approach. So we felt that locating the building in the area that had been previously disturbed was more consistent with Green Meadows' overall approach to conserve resources and be an organic operation. It also allows all those existing buildings to be replaced with a new greenhouse structure. Any questions on that? Next slide, please. Again, this is that same overall rendering again. Just wanted to touch, I'm going to touch on traffic and utilities real quick. So we prepared a traffic review letter that was submitted as part of the application. Based on the Institute of Transportation Engineers trip generation rates, so this facility, for just this facility, we calculated that there would be 37 vehicle trips during the morning peak hour and 36 during the afternoon peak hour, so 37 trips at the most. We conducted traffic counts on Asbury Street, just for context. Asbury Street, on the date that we counted, had 2,073 vehicle trips on Asbury Street. So we really don't anticipate the minor traffic that this facility will generate to really impact traffic on Asbury Street or any of the other surrounding areas
Can I
in
ask you a question?
Hamilton or
Both
Topsfield.
those numbers, 37 approximate number,
Yeah.
is that a total of both employees and trucking traffic, or what?
So that is the peak vehicle generation. So that is the most during the peak hour. So it really accounts mostly for the employees all arriving to
I
work in the
understand.
morning
Got
or
it.
leaving in the afternoon.
Okay.
Correct.
Yeah.
Any rough idea what the old farm stand?
So, great question, because that was the next thing I was going to say. So that, like as we previously mentioned, that the organic working farm did have a crop share program that had over 200 members. So while number one, we don't anticipate the traffic that will be generated from this facility to have an impact, and it should be much less than the historic use of the site when it was that working farm with the crop share program. Another traffic item, just to mention briefly, is we did measure the site distances for the driveway, and they all exceeded the minimum requirements set forth by the Massachusetts Department of Transportation. Any traffic questions before I jump over to my favorite topic, which is stormwater?
Any idea from which direction the majority of your traffic might be coming?
In our traffic letter, we split it 60-40. I'd have to look at the letter on which way we actually split it, but that's in the letter.
Okay.
That letter will also be, I should note that that's going to be reviewed by the third-party reviewer. So if they'll be able to comment on that as well.
What was your criteria for doing the split? Why did you pick one side 60 and the other 40?
Do we need to know what the...
Because that's what my traffic engineer told me he wanted to do.
That'll do it.
It was based on his judgment. When they look at the overall road network, they just use their judgment to determine, based on the closest available roads, where they think people were coming from. Again, looking at the 37, when you split that 37 up 60-40 in one direction, I mean, even if it was 37 in one direction, I really don't anticipate that being.
No,
Yep. Any other questions on traffic? Okay. Next slide, please. So again, this is our overall grading and drainage plan. It's sheet CG 100 right out of our site plan set. So from a stormwater standpoint, we maintain the overall drainage patterns of the site through a combination of catch basins with deep sumps, sediment forebays, infiltration basins, and then a subsurface infiltration system. We achieve the required peak flow attenuation and groundwater recharge and stormwater treatment. We perform test pits on the site to observe soil conditions and determine where seasonal high groundwater was. All the calculations that we did as part of our stormwater analysis took into account those soil conditions and the depths to groundwater. We submitted a detailed stormwater management report. It's one of those very thick reports you guys have on your desk there. And that was done in accordance with the Massachusetts Stormwater Handbook. We also prepared a detailed erosion and sediment control plan, construction sequence, and operation and maintenance plan. All that information is going to be reviewed by the third party. I love to talk about stormwater, but I was going to leave it at that unless you guys have specific questions. I'm happy to go into more detail.
Just what are you doing with the roof runoff?
That's my next slide.
I keep doing that to you.
Okay, we'll go to the next slide. So, again, this is our overall utility plan. It's sheet CU 100 in the site plan set. The proposed utilities for the project include new underground electric and telecom, and water services. New underground electric and telecom will come on the southern side of the building. There's an existing water line that already runs down the driveway that's located here. We'll be tapping off of that for our domestic and fire service, as well as to install a new hydrant. That hydrant location was placed exactly where the fire chief drew it on the plan when we met with him. As I mentioned, we have mechanical spaces located here behind the building to the northwest. In that area, there's underground propane tanks and an emergency generator. We're proposing a septic system in front of the building located here. That will be permitted through the Hamilton Board of Health. We're also proposing site lighting. Site lighting is provided on 20-foot tall poles with LED fixtures. Poles are mounted on concrete bases, and the lights are powered by underground conduit and wiring. All the fixtures are full cutoff lights, and we prepared a detailed site photometrics plan, which was included in the site plan application, which will also, again, be reviewed by the third-party consultant. The portions of the greenhouse that have that translucent roof will be equipped with motorized shades that will be programmed to automatically close at night, so that if lights are on in the building at night, they will not leave the building. The water usage, so I'll go through the numbers, and if you guys have questions on it, you can ask me. But
are the lights grow lights, or are they just for personnel?
Yes, the cultivation areas of the greenhouse facility have grow lights. That's correct. There's also obviously regular lights, emergency lighting in the facility as well. The water demand is anticipated to be 7,500 gallons per day for the fertigation, so that would be to water the plants. And then based on Title V, we anticipate for the 50 employees, 15 gallons per day per employees, which comes out to 750 gallons per day. In total, that total demand is 8,250 gallons per day. I do want to note that the fertigation demand, that 7,500 gallons per day, that's the maximum demand that we anticipate needing. Depending where the facility is in the growth cycle, the plants typically need more water towards the end of the cycle. So that 7,500 may not be needed at all times, but that's the maximum. So the total maximum anticipated combined is 8,250. The building currently has 6 5,000-gallon water tanks proposed, which will have 30,000 gallons of storage, with the ability to add 2 more to expand up to 40,000 gallons. Those tanks are intended to collect both rainwater from the roof of the greenhouse, as well as condensate from the mechanical equipment. That water will be reused both for fertigation as well as for gray water, for flushing toilets and things of that nature. The system is equipped with an exterior fill so that in a drought situation, the applicant can bring in water from an off-site source. Based on that 8,250 gallons per day, 30,000 gallons of storage, it allows the facility to operate for a little over 3 days without needing any external water for fertigation. And the expansion would allow it to run for almost 5 days, again, in a worst case scenario when they need that full 7,500 gallons per day for fertigation. Another thing that we wanted to note is that the system is designed, whether it needs it or not, to use the water that's collected in the roof first. So whether it's August or April or May or whatever the other rainy months are, October is usually pretty rainy, the facility is going to use the water that it collects from the rainwater harvesting system first. Again, and that really fits into the applicant's overall goal to be organic and environmentally sensitive. I feel like there was one other point I was supposed to make with the system. Yeah, the
rainwater collection?
Yeah.
Cover that.
Okay.
Yeah. Well, I know at one point when you came in the first time, you mentioned something about recycling the water that was then, that drips through the plants and you collect that.
Sure.
Is that still?
So the water that drips through that eventually gets to, the water that gets on the floor of the facility will be collected in floor drains and piped to an outside holding tank. The fertigation system has been designed so that if we have the ability to capture that fertigate water as it goes through, but it's really to be watered on like a drip irrigation system. It's not like the grocery store where it sprays the water out. Bob's not going around with a watering can. So it's all computer controlled and really designed to not have a lot of excess water from the agricultural use. Again, trying to minimize the impact that the development has. Any other questions on the, yeah?
The aquifer that you're citing this building on.
Correct.
That aquifer is severely stressed as it is right now. So for your operation to be water neutral, if you'd say, would be very desirable.
And that's why we've gone and put these holding tanks in, so again, we can collect
Really
rain.
describing as cisterns, which are becoming more and more popular.
Yes.
I would also suggest that it would be timely for you to conference with the Ipswich River Watershed Association.
I believe we're meeting with them tomorrow.
You say hello to Wayne. I'm a member of that, so I
Yeah.
pay attention to it, you know.
Did you have something, Pat?
He took my point.
Okay. Any other questions on the water usage? I mentioned.
So real quick, just, I don't know if you've probably done it, but say you get an inch of rain, what does this roof generate in terms of gallons for an inch of rain?
29,000 gallons.
Okay.
Glad I did that calculation last night before the hearing.
He was very impressed.
So just to follow up on that, just
Sure.
Because it sounds like we would have done this calculation as well, is on an annual basis, how much do you expect to capture?
I didn't do that calculation. Sorry.
Well, it would be interesting to see, taking the annual rainfall, of which I think is like 42 inches, 43 inches.
Sure.
How much that would generate based on what you expect to use?
Yeah.
What
We'd be happy to go back and look at some historic data and evaluate what that could generate.
That would be actually probably.
That's what I was doing, yeah.
Well, so.
Has to be at the right,
Q
the right time.
Q equals CIA, right?
So just as a point of clarification, because now we're talking about stormwater again, a tenth of an inch of rain does not equate to a tenth of an inch of runoff, because you have initial abstraction, which is the amount of water that just rains but doesn't actually drain, so evaporation and things of that nature. But I did do a couple of quick calculations, so I can, because you guys are asking. A tenth of an inch of rain is 450 gallons. A quarter of an inch of rain is 3,750 gallons. Half an inch of rain is 11,600 gallons. And again, I would just anecdotally, it's not that uncommon throughout the summer to get a half an inch of rain. 3/4 of an inch is 20,200 gallons. And as I mentioned, 1 inch is 29,000. Any other questions on water?
What happens to the water after if your tanks are full?
So it's been designed, so the reason I didn't talk about the tanks in my stormwater section, I talked about in the utilities. Our stormwater design, when we did a stormwater design from a site standpoint, we did not account for those holding tanks. So we assumed that all the stormwater that runs off that roof goes into one of our BMPs, so those infiltration basins or the subsurface system that I mentioned. That's a more conservative approach when we're looking at trying to attenuate the peak flows. Those, the cisterns that are located in the building, they're equipped basically with overflows, so if you do get more rain and the tanks fill up, it'll just overflow out of the building, just like it would on a normal building, basically, that didn't have that. All right, the generator. So as I mentioned, the generator is located in the back of the building here on the western side. It's been sized to power the entire building. The only thing it's not going to power is half of the grow lights. It will only run when needed during an emergency outage, except for it'll run just like everybody else's generator once a week for maintenance.
How many kilowatts?
Do you remember how many kilowatts the generator is?
Not off the top of my head.
Okay.
We're exploring multiple options.
I didn't think you would ask. I thought you'd be asking questions about sound, which is what I was ready to talk about. We can get that number for you. It's in a level 2 sound enclosure, which means when you're standing next to the generator, you can expect to hear noise levels between 61 and 72 decibels. Just for context, most sounds that we hear in our daily lives are between 30 decibels and 90 decibels. Conversation that you have with someone 3 feet away is 65 decibels. It's very likely that I'm talking louder than that at this current moment. 80 decibels is, and I joke that this is becoming a dated reference, but it's a telephone dial tone or a garbage disposal or vacuum cleaner. So again, 65 is conversation, 80 is a vacuum cleaner. The generator is anticipated to have sounds when you're standing right next to it between 61 and 72. So standing right next to that generator, it will not be any louder than a garbage disposal or a vacuum cleaner. And it's been located behind the building, far away from both Asbury Street and the abutting properties. Next slide, please. Okay. So the last item that we wanted to talk about is odor. So per the host community agreement, the applicant is required to control nuisance odor at the site. This has been a very sensitive issue. It's been something that Bob has charged us with to get a state-of-the-art system. We've been talking about it since day one. And Green Meadows wants, again, to control nuisance odor. They, again, I want to just reemphasize this again, they want to be a good neighbor and a community partner. Typically, odor becomes a problem not only at cannabis facilities, but any other type of agricultural facility when it's not addressed from the beginning. We are addressing odor from the get-go. It's been incorporated into the design since day one. We're proposing a robust, state-of-the-art system that we are confident will control the nuisance odor. It's been successfully used in a variety of other industries as well as the cannabis industry, and it will be reviewed by the town's third-party consultant. The way the system works is at all the exhaust locations, it generates a high-pressure fog to treat the air before it leaves the facility. The fog encapsulates suspended airborne molecules and injects an organic odor-neutralizing solution. So it's not just masking the odor; it's eliminating the odor through the organic odor neutralizing agent, which is a bonding molecule that bonds to the air coming out of the facility. It's computer controlled and backed up by the emergency generator. The specific system that we're using, again, has been used successfully throughout the country, and particularly in the cannabis industry. That was what we had to present to you guys tonight. As Bob mentioned, we're here, to answer any questions that you guys have.
Are there any local uses of that equipment or in mass?
Of the odor control, we have to check on that. It's been used definitely throughout the country. I think we're aware of a use. It's currently being used in Rhode Island, but with Massachusetts being newer to the cannabis industry, we'll check on that for you. We did submit, as part of the site plan application, one of those appendices has a lot more information, including some information of some case studies that were done for that specific system.
Brian, can I say a few things? First, I'd like to introduce Jeff Max Tudis. You want to stand up, Jeff? Just so everybody knows, Jeff works with the Beta Group. They are the multidisciplinary engineering planning company. I believe you're from Norwood, right? Norwood. Yeah. And they're the company that we've used on a number of significant projects in the community before. The town has engaged Jeff and Beta to be our peer reviewers. As Kevin has mentioned, there are a number of different areas where we'll be getting some real scrutiny on reports that have come from the applicant that Jeff and his counterparts will provide for us. So thanks for being here, Jeff. Some of the things that you know, and you've referenced that the host community agreement, it has a whole long laundry list of items. We'll work through those items. We'll also work through those that are required as part of the site plan review. But a short handful of things that I wanted to just put on the table to be discussed either now generally or in detail later is talk to us about your security program, what you intend to do relative to that. To me, one of the important things that we want to make sure of is from the exterior, i.e. Asbury Street, that we have the best possible or the least impact in view that's possible. And part of that has to do largely with landscape improvements, design. So I'd like to have you talk to us at some point with a landscape architect relative to what's your design theme, what's your design approach, what are you intending to do relative to upplaying the building, downplaying the building, dealing with screening, whatever those kinds of things are. And then the practical kinds of things relative to landscape, irrigation. You know, you've talked to us some about a new term that you had that I'm not familiar with, fertigation.
That's interior irrigation, if you want to think of it that way. So that fertigation is the watering of the agricultural inside the building. Okay. Do you want me to start addressing stuff?
I have one more.
Go ahead.
You know, we're all concerned about mechanicals outside. You've talked to us about the generator and its level of noise. You've talked to us about some of the odor scrubbers and that sort of thing, but we want to make sure of what's going to be on the top of the buildings and in the exterior that people have to listen to one way or another. So I just wanted to put those things on the table for consideration now in general and in specific later.
Sure. Can I speak to a couple of those things now? All right, so the security, so I think the most important thing with security, Green Meadows has retained a security consultant to do a detailed security plan for them. All the security items are regulated by the state, kind of at a high level. Some of the security things that are required, a 24 access control to the building to restrict unauthorized access. There will be interior and exterior security cameras as well as security surveillance storage equipment. In the site plan application report, we included a cut sheet of the exterior camera. It's kind of like the same camera you would see at like a CVS or a Walgreens. It's just a little eyeball camera. Those will be located on the building, and the site will have dedicated on-site security personnel during hours of operation, again, as required by the state regulations. We've been in contact with the police chief. He's been part of the conversation every step of the way in terms of the security. From a view standpoint, we're not proposing any chain link fence and razor wire. Like I mentioned before, all we're proposing for a fence, and it's solely for visual, is that wood split rail fence along the front of the building. So that fence will sort of run down this driveway, around the front of the property, and then sort of back up and sort of return in. And again, I'm happy to bring our landscape architect to a hearing with us, but again, in general, the theme for the landscape architecture was really to try to keep this a more equestrian or a farm feel. We truly believe that if you didn't know what this facility was, you could drive by it every day of your life and you'd have no idea. You just think it was a greenhouse, and it's just as Bob mentioned, it's an agricultural use. It could be growing, yes, we're growing cannabis in the building, but whether it's cannabis or carrots or lettuce or tomatoes, I like avocados myself, you know. It really makes no difference of what the outside of the building looks like. I didn't speak to it, but it's in the site plan application. We're proposing a small project sign that's located in the front driveway, really similar to what's out there today. It's just going to say Green Meadows on it. Mechanicals and noise, be happy to get you some more information on what more of those mechanical equipment is. We don't anticipate it, and I believe in Beta's proposal, they have a specific line item to review noise in accordance with the HCA. We do not anticipate this facility is going to generate nuisance noise. I think this facility is going to generate less noise than has been historically seen on that site. Again, when it was a working farm, you had tractors, the crop share program, you had people coming in and out. The facility won't have that moving forward.
Do you have any elevations of the building in your presentation tonight?
I can pull up the site plan. They're in the.
No, I know. I just wanted to see what he's got. If there's any color.
I'm just curious about the process flow. What happens in those buildings?
We can.
Yeah. Well,
Yeah.
maybe it's in the.
So I'm wondering if
Before, if I may. Again, I just want to clarify, this is sheet A501. It's in the site plan application that we submitted.
Right, and I've diligently reviewed the electronic and hard copy versions. So what might be helpful is if you could apply in future presentations is color.
Sure.
Or texture, so that, because this is like, it looks like an architectural drawing, but it's kind of sterile. So it would be helpful to give it some color so we get an understanding how it blends with the surrounding. Because as I understand on one, and it may be the east side is going to be barn board.
So yes, so the renderings that we that I showed in the presentation, I will get those to Patrick electronically so he can then distribute them, so you'll have that for your reference. But that is a good point that I didn't mention. The greenhouse itself, it's a corrugated metal side, but the east side, the east elevation, the side that faces Asbury Street, that's proposed to have, let me make sure I state it correctly here. A wood board and batten siding. So again, again, I'm an engineer, so probably my opinion isn't the best one. I think corrugated metal looks nice. But that wood siding is really, again, to go above and beyond. Again, Green Meadows wants to be a good neighbor, so we're really trying to make this building fit in with the context of the neighborhood.
Yep. So that would be my only request, is colorize.
Sure. We can absolutely do that.
Thank you.
Yep.
Could ask you a few things. One is Asbury Street in the Hamilton section. I'm quite sure that's a designated scenic highway.
It is, that's correct.
So you'll need to pay some attention to that, and that would come before this board when that's appropriate, you know.
Right, and go ahead.
You're doing a very good job. I
thank you
for being very concise. You might have already covered it and I missed it, but the other two things that would be of concern to me would be pesticides and fertilizer.
Sure.
It's not my my area, but that is our aquifer, and it's the only one we've got.
So from the scenic road standpoint, with the exception of the improvements that we're doing to the driveway that were requested by the fire chief, and whatever is in National Grid, whatever National Grid requires for the electrical service, we're not proposing any other work in that right-of-way. So the impacts to the actual road itself are anticipated to be very negligible.
we're very proud of our stone walls and stuff, so.
We also like the stone wall very much. Like I said, we'll be reconstructing a small portion of it where the fire chief has requested us to widen that access. But we're gonna reuse those existing stones. Hopefully Sean will make it look much better than it does now. I don't wanna use the word pesticide because I
would understand that, yeah.
But to address your question about the pesticides, all the materials that will be used as part of the agriculture process for this facility are organic. And they're organic.
Organic, okay.
And they will be kept inside the building. As I mentioned, I think I mentioned it during the presentation, in any of the floor drains in that building are piped separately to a holding tank that gets pumped out and disposed of. It does not go to the septic system or the stormwater system, and as a result, does not have a chance to get into the ground and into your aquifer. So this proposed facility should have no impacts on that aquifer from that standpoint.
And you're treating fertilizer the same as pesticides?
Organic.
Organic.
It's all organic materials.
Any other comments from the board?
I'm pretty ignorant about process. What is the process going on? Is it continuous, crop after crop after crop, or?
Do you want to guys
I don't know what.
Speak to that?
Is there a description in the?
Yeah.
Yeah.
So I'm gonna introduce Ben, who's the director of cultivation.
Right.
I'll just stand by for.
So the harvest schedule is going to be a perpetual harvest schedule. There's roughly 7 different flowering bays, and those will come down in 2 segments on a 4 or 5 day cycle. It's a total 63-day harvest cycle from the time they go into flower, but the time that the plants are introduced will be staggered on those 4 to 5 day cycles. So every week it'll be the same harvest, drying, trimming. We did that to really kind of like minimize the amount of labor at any one time and spread it out and keep it even.
And then, so once you harvest it, you're pressing the leaves for oil?
There are some extraction processes that'll go on. For the most part, it'll be hung and dry and trimmed. It could be packaged as raw flour or processed into either infused products or concentrates.
I just want to put on that point, I think, again, it's very important to note the farm stand that existed on that property processed agriculture, right? They made pies, cookies. What was the other thing you told me they made, Bob?
You're not making pies and cookies at this facility.
But it was in,
brownies, yeah.
I think it's important to note it's an agricultural process. So I think that's just very important to note that it's, again, yes, it's cannabis, but we're doing the same thing on that site that they've been doing for years. Really, the only difference is it's now all going to be indoors.
One of the differences also from the previous site was that the farm stand had people coming and actually buying product.
Oh, yeah, that's true.
No one is coming there to buy product.
Right.
That's correct. That's a good point. Thank you, Sean.
You're wholesaling or whatever.
So, right, this is a cultivation site. All the material that comes out of the site is sent to a dispensary for sale. You cannot come, the public or anybody cannot come to this site and purchase anything. That's a very important thing to know.
What? Yeah, I just want to get all the board questions, and then I'll address the audience. Any other questions from the board for now?
You mentioned the building walls would be board and batten at this point, your third. That doesn't impress me as an individual. I'm wondering if that subject might be up for discussion somewhere along the line.
Are you talking about the siding on?
Siding,
it's important to the applicant that the building fit into the natural character. I think if the board has other suggestions for siding materials, the applicant, sure, Bob.
It's Bob Patton again. Just in general, this evening we were looking at side colors. It is metal on the sides. It has a sort of a, pseudo ripple to it. And we're looking at colors, obviously, that are in keeping. They're earth tones, barn colored. I thought the front panel along the road, which will of course be sort of cupped on either side by the screening, to have that as some kind of a barn siding. Now, what is barn siding? You probably know more specifically the options. I just said I kind of want it to look like a barn on the side, and I left it at that. So we'll figure that out. But suggestions that you have, that's sort of an open item at this point specifically. But that was the look that I wanted. It seemed to meet with favor to people we've talked about on that front-facing road. Exactly. So again, but the color of the metal on the side again will be barn-like in itself, but I really thought we'd go with wood on the front face. That's all.
Anything else?
Are you going to use new wood or old wood?
Sir, I don't honestly know. Haven't gotten quite that far.
I get that.
It's on my list tonight. All right. Thank you.
Any other board comments? Good for now? Okay, I can now take audience comments. But you have to come up to the microphone and introduce yourself and state your address.
In a way, I don't belong here. I'm Christopher Abbott, lives in Topsfield. I am the only abutter to the property. I have so many concerns, it's not even, but I'll start with the gentleman made a statement that whatever noise was on the outside would be in no way different than the farm was. But at 3 in the morning, the farm made no noise. At midnight, it made no noise. At 2 in the morning, we like to sleep with our windows open. Am I going to hear anything at night? That's number one. Number two, 20-foot tall lights, if I got it right, LED, on all night. Will we see them? As you're a butter.
I just list them all out and then we'll.
No, those are the two.
Okay.
I'm not going to list them all because we'd be here all night. So.
And there will be further hearings, obviously, or meetings. So.
So again, just for the abutter, again, everything that we're doing here is going to be peer reviewed by an independent third party. I just want to reiterate that one more time. In terms of noise at night, I believe that's controlled by the HCA. We will not be testing our generator at 3 o'clock in the morning. That's going to be during the week sometime between 9 and 5. We don't anticipate the facility to generate any noise at night. The 20-foot tall poles are full cutoff, so they don't have light trespass. There is a detailed photometrics plan that's included in the site plan that shows that there's no light trespass at the property line.
But,
And the lights
you will see it from a distance. Obviously, there's light coming out of those fixtures onto a surface.
That is correct.
From a long distance, you'll be able to see that, just like any light.
Correct,
Right.
but it is full cutoff.
Yeah.
And the lights are also dark sky?
Yes.
Yeah. Cut off is.
Expected that.
What does full cutoff mean? I'm sorry.
Yeah.
So full cutoff, like the best way I can explain a full cutoff light is if you go to what your preference, local hardware store, Home Depot or Lowe's, whatever your preference is, and you get a floodlight and you put it on your garage and it kind of those big fluorescent bulbs that shine down, that is not full cutoff. That is a light that I can see the Christmas lights on the house over here. Those are not full cutoff. Full cutoff means that it's shielded so that the light only shines down and that you cannot see the light from a neighboring property.
There's nothing coming out of the top of the light. It's a dome.
But the light will not shine into, right.
Correct.
There will not be floodlights like you see on the side of the highway shining into an abutter's window. That's what full cutoff means.
Right. What are the hours of the facility?
7 a.m. to 8 p.m. max.
Just a question. Probably some of this is security lighting that's required by
Correct.
state regulation.
That's correct.
So that would be important to understand when you're describing this in the future, when that
Yep.
comes up for more, is to.
Cameras are infrared too, so they don't that's for night. They don't need light to see.
Are well, you already said that at night, the shades in the roof close.
Correct.
So you won't see those grow lights coming out. What about on the sides?
The only windows are on the west side of the building, so that's the back of the building where the generator is. They're shown.
Yep.
I lost my pointer now. Shown right here. That's not the agricultural grow space. That's like administrative space. So there's no windows in the agricultural spaces of the building.
To be clear on the hours, 7 to 8.
Oh, sorry.
Chris Sawaki, COO, Green Meadows. The hours in the HCA, 7 a.m. to 8 p.m., restrict outside of those hours the noise that the facility can generate. But if somebody's cleaning up after the hours of 8 p.m. or before 7 a.m., there can be activity in there. It's just noise restriction, just to be clear.
Brian, could I ask one other question? Just came to, maybe you addressed it and I missed it. How about property security? I know you said you're going to meet with the police chief. That's fine.
We've met with the police chief.
Met with the police chief.
And we will continue to meet with the police chief.
And that's roadway traffic, I presume, most likely. But
No,
you put a big parking lot out in the middle of the woods without some guidance. You could have nighttime visitors that you might not expect, And,
So that would be something that's.
I'm not saying security of the buildings, just people.
I think that would be dealt with as it would be dealt with at any other, again, whether it's an agricultural facility or if
A
it's
little further on the list than what.
So again, if there are people doing whatever mischievous activities they want to do, and trespassing on the Patton's property, I think that's something the police would have to deal with. But I think we have to deal with that no matter what the project is, kind of thing.
When I was younger, I used to look for a place to go parking,
There you go, Ed. You're all set.
That's what you just wanted to talk about his party days. That's what.
And Mr. Mayor, I had one question for you, so if you don't mind staying on, because I was that's you. Thanks. Good evening, Ben Timon. I'm counsel to Chris Abbott, who spoke at 123 Asbury Street. One question for Mr. McGarry with regard to the materials that I know you don't want to call pesticides, but that are included in the application materials. So there are 27 different substances for which you included material safety data sheets, and I just wanted to confirm that those are the materials that you intend to use at the facility. Is that right?
Yeah, so that list that we included in the site plan application came directly from Mr. Bork.
So, for the most part, the majority of the Benjamin Bork, the majority of the substances provided with the SDS sheets will be used, but the quote-unquote pesticide list was a preliminary list of just potentials. Since then, I've had a couple of communications with the Department of Ag, and in Massachusetts, only 25B exempt products are allowed to be used on cannabis, which means they're minimum risk pesticides that don't require the same scrutiny as normal pesticides to get an EPA registration number. So there is no registration number provided. Most of the time they're plant-derived oils. Most of them are essential oil-based or neem oils and things like that.
Okay, thanks. Thank you.
Again, we don't want to call them pesticides, even though that's the word that keeps coming up.
We know. So I wanted to be respectful of the board's time. I gather that Patrick may have circulated a letter that I provided on behalf of Chris and Deborah Abbott. Just to give you, to orient you to their property, on the first page of the site plan, their property is indicated. It touches corners with the Topsfield piece of Green Meadows Farm, which under the host community agreement that your Board of Selectmen approved, originally had some parking for this facility on it, now no longer does. But they are abutters, two abutters, and
Can you point out where they're?
Yeah.
yes.
Is their house shown on this?
That upper corner, I think.
So they're to the north. It's hard to, they're here.
No.
Nope,
right?
next one.
What's that? Someone
Up,
say no?
up farther.
That's my mother's house.
Yeah, she's here, I think, right?
Yes.
Yeah.
I believe
And the Abbotts are here.
this is the house.
And that's their house. Right there. So they're the, apart from Mrs. Patton, the Abbotts are the closest residential abutters to the facility, over the line, obviously in Topsfield. So again, I want to be respectful of the board's time, and it sounds like obviously there are going to be future sessions, and so I don't think it's useful tonight for me to go point by point through each of the impact areas in my letter, but each of those areas, as I explained in the letter, are of serious concern to us. I do want to make a broad point this evening with regard to the mantra that we've been hearing tonight about this is just agriculture. They're not growing carrots or avocados here. There's a reason why the host community agreement includes 14 separate impact areas that are supposed to be evaluated carefully by this board, which I know the board intends to do. There's a reason why this is a very tightly regulated area by the state and by localities. And as I point out in the letter, and I made this point as well when I was before the board in the fall, talking about your bylaws, when the legislature passed the medical marijuana statute, they specifically exempted the cultivation of marijuana from the agricultural exemption in the Zoning Act. And that's footnote 3 on page 2 of my letter, a quote from the Cannabis Control Commission making that specific point. So this is not, your father's agricultural type of zoning regulation. This is something very, very different, which is why we're all here. So the impact areas are quite clear. There are serious odor issues to be concerned about, as I point out in the letter, and I think one of the areas that I hope will be considered by the peer reviewer as well is, are there examples of where this FOGCO system, the odor mitigation system that's proposed to be used, has interacted with the pesticides? I know we don't want to call them pesticides, but several of these chemicals that are included in that appendix with MSDSs are pesticides, and some of them are actually banned in certain states. And so if those pesticides are being used on the same plants that are emitting the odors that are being captured within this fog and then sent out, what does that mean as far as toxins and pollutant drift and that sort of thing? Has that been studied? Have there been facilities, cultivation facilities, that are as close to drinking water sources as this one is? I'd encourage each of the board members to go out and visit cultivation facilities that exist in Massachusetts, and you'll find that all of them that I'm aware of are in industrial parks, essentially, or industrial areas. The one in Georgetown right off the highway, there's one in Amesbury, an industrial park. There's many in central Mass that are in industrial areas, because this is much more of an industrial use than it is an agricultural use. So those are just broad strokes that I wanted to make this evening on behalf of the Abbotts. And we look forward to, in the future sessions, going into some of the substance on each of these points. But I think and hope that the board will very carefully examine and put the applicant to its burden of actually demonstrating that this can be done safely in this environmentally sensitive location. And happy to answer any questions that the board might have about my letter or the concerns that the Abbotts have.
Any questions right now? Not yet. Thanks. Great, thank you. So Patrick, timing for review from our peer reviewer. Do we know what that will be yet in terms of, will it be kind of section by section time frame, or will it kind of be all at once? We'll get.
I think it's best to go section by section. There's only so much that you can handle at one time. Typically what happens is that the reviewer creates a review product. It then goes back to the applicant. The applicants and engineer and technical experts review that, and then they provide their opinions, and it then provides the board with a work product with which to allow the board to make decisions on.
Yeah, so when we get a comment letter from Beta, which hopefully Beta will give us their Word file so we can do a little copy and paste, but we will repeat every single one of their comments and then just give a statement of how we're addressing. So when we do a resubmission, that'll have a cover letter, and then if plans change, stormwater calculations change, we will revise all that documentation, and we'll go through every comment. And light pole location has been adjusted on sheet X. So that's how we typically handle those types of revisions.
Yes. Okay, great. So timing, I guess, for the next meeting and when we might have, at least one section addressed.
Let me ask Jeff. Jeff, do you think that you'll have some product for the board at our next meeting? That'll be on April the 23rd.
Assuming we're under contract.
Yeah.
I don't know which sections we'll provide, but I'm assuming we can have some done by then.
Okay.
Can you provide a schedule so that we have some understanding of what section you will be reviewing and what dates you can provide your comments to the applicant?
Sure, we need all the applicant's materials. I don't think we have everything yet.
We'll make sure you do tomorrow. Yeah.
So we'd like to see that before we can commit to it.
Sure,
That's fair.
sure.
Yep.
No, it would just be helpful for us to understand the flow of how this is,
Yep.
because I'm assuming this is probably going to go through June. So I'd just like to know what the...
Yeah, that sounds about right.
I mean, get him a list of all of our meetings, and then we can, at X meeting, we're addressing X sections. Ideally, that's how it'll be laid out.
I'm sorry, Mr. Chairman, I had one other question that I think does pertain to the schedule. Under Ben Timon, counsel for Chris Abbott. Under Section 7A of the Host Community Agreement, it makes reference to a water impact study and states that the company agrees to pay for such a study. And it came up earlier today, some sort of back of the envelope potential projections on that score. And I made reference in my letter as well and attached a copy of the new Ipswich Watershed Association net zero use water policy that it strongly encourages towns to follow when they review development proposals. And so the question is, whether that's underway, whether it is expected to be presented to this board, and what exactly the plans are with regard to having some actual verifiable data with regard to water use.
Yeah, please, if you can.
So the numbers that we presented, I'd be happy to issue those again in a more formal letter. But those are the numbers. So we'd be happy to put that in writing and submit it to the board, and it could be something. I don't want to speak for Beta, but I'm assuming it's something that they obviously could review our calculations.
Right. And I'm assuming you're going to be reviewing that with Ipswich River Watershed Association tomorrow.
Yeah,
and like you
have
said,
a meeting with them tomorrow.
Yeah, and it probably would be helpful if you could assemble the annual rainfall totals you expect to supplement the public water supply use, just because I think it's going to be illustrative of what you're doing. So, and it will certainly help the general public understand, okay, they're using X, but they're capturing Y, and it's going to result in.
The other question might be, would it be realistic or possible to incorporate any climate change data that might affect the change in rainfall? If there's anything
Good luck
that's
with
even
that.
reasonable to do along those lines. Go ahead. If it's not possible, it's not possible.
I think we would prefer to rely on hard historic data than speculate on what future data could be.
It's fine.
If the board feels strongly that they want us to look at that,
No.
No,
Okay.
that's impossible.
Oh, thank you.
thank you.
Just a thought.
You're not an iceberg.
Well, you can't predict it accurately. Yeah, okay.
Great, thanks. So,
So do we?
We
do
need to vote
close
to
this?
continue.
we have to close it, we have to
Or
continue it.
continue it?
Yeah.
Okay.
Right.
Sorry, Freudian slip.
Yeah, unless you're going to approve it, then you.
No problem, no problem.
We've got closing things on our mind.
Okay, I make a motion that we close the site plan review.
No, continue.
I'm sorry. Somebody else do it. I make a motion that we continue the site plan review for Green Meadows Farm LLC and medical marijuana cultivation and processing facility.
So do we think we're gonna have anything by the next meeting? Or should we just,
We should have some product next meeting.
Second?
so I just wanna say continue until our next meeting,
Oh.
which is what, the
April the 23rd.
third, thank you.
Yes, amend that to continue to April 23rd meeting.
Okay. All those in favor?
Aye.
Aye.
Opposed? Great, thank you, unanimous. If you can shut it off, that'd be great. I think we're good.
I'm gonna go to the men's water.
Great, thank you. So,
Okay, yeah, it's nice.
They're perturbing me.
yeah.
More paper.
Yeah.
Yeah, thank you, nice job. See you next time. Take care. Nice to meet you.
Nice to meet you.
Like your first name.
So the board, no. So if somebody leaves mid, let's say, oh, I would then, well, the woman and the associates, there's two, they're keeping their jobs.
Okay.
Okay.
Yeah, we're still
Clark. Can I ask one question?
Yep.
Patrick, we have all these materials from, for the patent. These are copies we take home and bring back, or?
Yes, please.
So don't expect any future additional copies?
You know, we have everything electronically, but it's going to be helpful if you can hang on to your hard copies and bring them back every time.
There's so much.
Thank you.
So on to our master planning forum update. Our consultant was supposed to be here. They were here for a while, and then just gave Patrick a note that they had to go. A little too late for them, I guess. So I don't know if you just kind of want to bring us up to date, Patrick, on where we're at and what we have in front of us, and we've all seen it. But
right, we have a couple of products that they've provided us with. Judy has prepared the fiscal impact discussion document. Again, this is a draft document, but she has looked at basically development of housing and what that means to the town in terms of demographics, town finance, fiscal impacts, those kinds of things. She's looked at a number of different development scenarios. These are, completely theoretical. They're not on, a surrogate developments. They're just simply examples. So I don't want people to be excited or disappointed or angry that we've chosen certain sites. The sites that were chosen were basically sites that were talked about as part of the forum discussions that we had back in early February. So this is some of the outcome of that in terms of fiscal generation and what it means to the town in terms of cost of impact. The other item that we have provided to us is basically a summary of all of the housing profile information that our board members as well as the public that worked with us that night on February the 4th to provide us with a fair amount of information relative to likes, dislikes. We've got a lot of information here too relative to the demographics research that's been done, other information that's been done relative to what tastes are, et cetera. So a lot has been done by the consultants. I wish they were here to present. The most important thing that they need to get our input on is reviewing the fiscal impact discussion document, so we can get that finalized first. Has anyone had a chance to look closely at it?
Yeah.
Yeah, go ahead.
So I was a little surprised at the product, because I was thinking that this analysis was going to be done on based on our having gone through and reviewed some, well, that they were going to, based on this information, they were going to make some recommendations for zoning bylaws that they thought would be appropriate given their review of what we don't have and what we do have, and, maybe modifications to existing bylaws to enhance their applicability, and then do kind of like a financial analysis of what those options might, financial analysis of those options and how they would impact the town. Here they've picked just some, what's the word I want? Kind of like arbitrary, based on those conversations. Winthrop School site, Chabaco. Well, that's none of those are actually being considered at all. And in fact, I think this financial analysis is then going to drive the conversation of people going, well, why did you pick those? Those aren't developable sites. I understand they're illustrating the concept if you built these kinds. I was expecting that it would be more, it would be applied to more specific recommendations that we would actually be potentially implementing.
So basically more
generic,
not site specific, right?
Right,
but just
right.
more generic.
Right.
I mean, in a sense, it does that a little bit, right? In that it looks at a very large development. It looks at a
right.
Not a small, but a cottage development of 40 houses, and then what I guess you can say medium size of 60 apartments, but those are all relative terms, obviously. But
yeah, I mean, you got one big one,
yeah,
one medium one, and one small one.
Right.
So it's kind of like, well, here's one that's big, one's medium, and one's small, and here are potential impacts.
And the one thing that it doesn't do that I know was talked about, at least in our group, a bit at the first seminar, was like duplexes. What if we had more duplexes in town and allowed zoning for that? Right. That's been talked about some, and that was part of the survey as well. That was a big piece of that people thought might make sense, was allowing that kind of zoning. That's a little tough to do, obviously, but that was one major conclusion in the survey, which wasn't incorporated. I tend to agree in a sense that it was specific and generic at the same time, but I guess I was under the impression that I think that through this process they were then going to generate the zoning recommendations,
and then do a financial.
Well, maybe I I guess I was thinking that the financial thing was gonna happen, and then we talk about it, and then they'd come up with recommendations for zoning, but it seems like it's gonna put the burden on us in a way
Well-
to then, decide on what those recommendations are, which really should be coming more.
Well, that's my next question. What's the product that we're gonna get? So, I was thinking.
Well, I think we know what the product we might get is our recommendations, but how are those being generated? Who's generating them, right? Is it?
had sort of the same, I came to the same conclusion, sort of, because I got all done and I read, well, okay, so why did I read this? What are we doing here? And it wasn't as concrete as the two of you came up with, but exactly the same idea.
Well, so maybe it would be useful to go back to the scope, which I honestly don't remember. Patrick, maybe you do. Is the, other than the public participation to, I guess, present this information, are we expecting that they're going to provide some recommendations or actual language for zoning bylaw? Given an overview of where we are, our population, demographics, housing types, and the survey results saying, the population wants X, so we're therefore, are they crafting recommendations that we adopt zoning bylaws that address the survey, results? I'm just trying to get some definition.
What do you mean by a zoning bylaw, though? I don't get that.
Well, go ahead.
Sorry, the last master plan had specific recommendations for bylaws. I mean, it didn't write the bylaw,
Yeah, of course,
but
I know
right,
that.
senior housing,
Yeah.
states, whatever it was. I think that's what you're getting at.
Yeah.
Right? Or how to change our existing bylaws.
Well, let's take your example of, I don't know what a duplex is, but let's say
Two-family.
I did.
Two-family.
Okay, so, and we say, if you have this kind of housing, it's gonna have this tax impact, it's going to have this effect on, the.
Well, back up.
growth and-
Well, back up. The question is, will they be looking at our current housing stock, what the survey is saying is the potential demand or people want to see? Are they going to then recommend zoning bylaws to address those? And how specific will they be? And then my thought was, then they would do a financial analysis and say, well, if you build duplexes, two families, whatever you're going to call it, here's the kind of revenue you could expect. Or if you built, they come back and say, well, you have OSFPD that's supposed to promote cluster housing. You really need to change that and to make it more developer, more incentives for a developer. And if you build those, here's the financial impact. That's what I was envisioning, but that's clearly not what they were thinking when they put this together. So my next question is, what are besides the public participation and presentation, what's the final product?
It was my understanding, and I'll check the scope contract that we have with them, but it was my understanding they were going to make recommendations regarding suggested bylaw approaches that we could be taking. We would then be using those premises and generating bylaw article language as an outcome of that.
Right. And, I also thought they were gonna take the survey, kind of parse through that and, work on this analysis and obviously, potentially develop bylaw suggestions based on that. And what what the product seems to be, and I know the survey wasn't 100% done when she did this, but it was pretty close. You know, what we got was, or mostly, was exactly the opposite of what people in the survey said that they thought the town needed, right? You know, 7% of the people said they want a multifamily that's 20 units or larger. You know, that's a very small percentage, and then we got the houses on smaller lots was the largest percentage of what people wanted in the survey, which you could say cottage housing. I'm looking at the survey results.
Right, I was just wondering
What types of housing does Hamilton need more of?
Do you have a page?
Oh, sorry, 12. And it breaks it down by a number of different things. But, you know, the two scenarios, the 2 out of the 3 scenarios that they did ran numbers on were, you know, 60 and 150 unit apartment buildings and.
Which is what people don't want.
Right. Yeah. Which you know, I'm glad they did one of them, you know, maybe, you know, to see, okay, what's the impact on, you know, if we get a giant 40B in here, right? That, it kind of tells you that, but other than that, it's not based on what the town said that they were looking for.
Right, I think that's a very good point, is you would expect houses on smaller lots, rental units, and townhouses, as, for example.
Yeah, I mean, they did cottage housing, which you could argue, okay, that's houses on smaller lots, it kind of fits in that scenario, right? But, and rental units, okay, that, you could kind of argue it's this, you know, it could be 60 or 150 apartments, yes, but again, one of the bigger ones that was mentioned throughout the survey was townhouses. You know, those could be, you know, you could argue that's a duplex or connected, you know, 2 or 3 units connected to one another, but, you know, that's nowhere to be found, so, I mean, it'd be great if, I mean, we can chat with them if you want me on the call or whatever, when we do chat with them, soon, that maybe they can do that, you know, take their survey and parse it and then develop another analysis.
Well, I think, you know, clearly what you're seeing is you've got the survey going on and you've got Judy doing something completely different.
Right. Well, that's my point, is that this was supposed to drive this to a point.
That's what we thought.
Okay. Yeah.
And I think.
That's what we were told.
Okay.
Right, I thought, right? I mean, the survey and the, you know, the first public meeting that we had, and yeah, there was talk of larger development at that meeting, but, you know, there was also talk of a lot of this other stuff as well, so.
Yeah.
So yeah, I think we have to have that conversation with them soon.
Yeah.
And go from there. But
yeah, I think that would be very helpful. Just so you can sort of. I think we need to get reoriented as to what we expected and what they think they're delivering, and.
Yeah, because we know what, you know, if we came out and proposed a bylaw that allowed, you know, 20-plus unit apartments because it generates X amount of money, you know what's going to happen, right? It's that we don't want to do that, but you know what's going to happen. So it's almost, I won't say it's completely useless, because it's not, because it gives us a sense of what would happen with a, you know, a little more sense of what would happen with 40B
it's a nice sort of general. Hey, here's big, medium, and small, and here's the financial impacts, as opposed to, well, based on what your town needs, or the people are saying we need, here's what we think you would probably, the type of housing that you would want to pursue, and we're going to pick an example and run a financial analysis on it. Right. Because it's like, so.
I mean, should we just, instead of them parsing it, which they obviously didn't take into account, should we just say, look, we want you to look at, based on this, we want you to look at.
Yeah, I think, yeah.
Well, and I was wondering about based on the survey, how much emphasis we need to put on one kind of housing versus another. Like, what does it tell us about what the demand is for some different kinds of housing?
Right. Right, and I think there's, you know, it looks like a pretty decent demand for various types of housing, right? I mean, rentals, that's a pretty broad range, right? You can have duplexes that are rentals. But, I don't know, I'm not sure, you know, really which one we want to look at, because then that's kind of us dictating it based on this, but I don't know what everybody else thinks in terms of what we should have them look at if we're going to go down that route. 'Cause I think we should get at least another assessment on something, or another study on something.
Patrick, where are we in terms of budget expenditure?
I'd say we're probably about 2/3.
That they billed and we paid for?
Yeah.
So, I just, you know, I have to say that, you know, I don't mind them doing one of these, the 60 and the 150, I don't mind one of these, but I think 2 was kind of a waste of time, and we should have been looking at something a little bit more relevant. So, I think they absolutely have to do that to make this useful at all. So, I think we should just, I mean.
Yeah, because what's gonna happen is, if you were to take this document from Judy and put it out in the public, they're gonna say, well, oh, they're proposing 160.
Yeah.
Yeah.
And that becomes the headline.
That's right.
And what you want is for it to say,
Yes.
look, we did the survey, this is what people want.
Right.
Yeah.
And now let's do some costing on it and put
Right.
them into one document.
Right.
even.
Right. So, I don't know which of these we want to look at. I mean, houses on smaller lots, I think you could say, okay, we've probably covered that, right?
Well, I think the cottage housing kind of covers that.
Right. In rental units, that's that's very broad. Townhouses, you know, the townhouse duplex thing, at least to me, stands out, and I read, as I read through this, I heard duplexes a number of times, and as well as townhouses. And we already have senior age restricted.
Right.
We have that bylaw. Physically accessible units, I understand the demand, but that's not a type necessarily. So to me, the kind of the townhouse duplex, which you could say they're very similar in some ways, but I mean, a duplex is obviously on its own piece of land typically, whereas townhouses can be a condo type development, but
Okay, so it sounds like you guys gotta have a conversation with her, with.
Right.
What are you thinking, Patrick?
I think that I need to either have one or both of you guys in my office, and we'll call them and have a focused conversation.
Mm-hmm. Yeah. I might have to be on a conference with you, but, yeah. No, I think that's right.
Good.
Okay. I mean, the other thing, they did have, at the end of this, questions for the planning board that revolved a lot around, enrollment in the schools, and, I guess that was one of them, but, and kind of looking at the projections where Wenham is, where we are, and that, they're looking.
Do we know if Judy ever connected with the finance committee?
I never got a CC of that. I know she was attempting to. Phil Stearns is pretty good about getting back to people. I think she was working at that like 10 days or so ago. I'll find out.
Yeah, they're asking, does the board agree that we should be using any STC enrollment projections to estimate the town's future school budget assessment?
Well, the town did it.
Right, right, and she talked about that.
Did they use that? Because the schools did a strategic plan.
Right. Yeah, I don't know exactly, it doesn't say exactly what the school used. Wait, I'm assuming.
What do you think the strategic plan was, Rick? I didn't get it.
The school's plan.
The schools, about 5 years ago, did a strategic plan,
With family size, is that what it?
Well, they
variable
were
is
looking
that's
at what was enrollment, among other things, what was enrollment gonna look like
Yep.
over the next 10 years.
But how do we get to the family size and the housing needs of different populations of students?
Well, I think they're just estimating what certain types of housing generate for, for kids, right, in the system.
Okay.
And it's just looking right now what Hamilton's, the projected decrease of 105 students, while Wenham is projected to gain 60 over the next 10 years, is what the school system is projecting right now. So one of their takes was, taking the highest impact project, the 150 apartments, leads to an increase of 46 students, which changes Hamilton's 10-year enrollment projection from a drop of 105 to 59. Or, even with something like that, they're saying you're still losing kids, right? So.
So is that a conversation you can have in the next few days?
Yeah. Yeah, I guess that's fine. Although it's a crazy couple, Wednesday, Thursday, Friday are kind of crazy, but I can talk and draw at the same time. Yeah.
Okay.
So let's figure out when they can do that, and
Right.
they can meet a couple times and try to make that work. Just not Friday morning.
Delivery date.
Are we good with that right now?
Yep, I think so.
So then now we just need to vote on the very minor change in the sign bylaw, right?
Right. Yeah, we were, when we made the last change, Donna said that, town council said that, based on that, we're gonna have to make some, changes, on
Adding
the
that-
floor.
Yeah.
At town meeting, right?
Right.
So,
Yep. It's basically just adding in this underlined text, right?
that's correct.
I underlined, you mean the highlighted stuff that's on the text that she has in there?
My copy here has underlined.
Oh, yeah, I see, I got it.
Oh, well, yeah, there's.
That's on page 2?
Yeah.
Yeah. Yeah, I guess there is a couple highlighted things as well, you're right.
Right.
So that's the only language?
Mhm.
Okay.
Yep. We got an email from Bill Olson that
Yeah.
was sent to her today, too.
Well, because I think I looked at that too, and I know how he read it. It talks about in residence districts, no more than 2 temporary signs per contiguous lots with the same ownership. And then in the definitions of temporary signage, it talks about 5 lawn signs per lot, but that, to me, was for election signs only, right? And then for other signs, it's 2.
That's temporary signage, it's number 4. there's 6
Right,
and 5.
right. So, yeah. Yeah, I guess I always thought that I just read it that it's 5, we can have 5 election signs. I think that's how it's supposed to read. But then other types of signs, you can only have 2. Am I wrong in that? That's what I thought.
That's what my understanding
Okay,
was.
yeah, I guess,
Somewhere I saw that it said that. I saw it.
so,
Okay, so we need a,
6321,
Yeah.
no more than 2 temporary signs per contiguous lot within the same ownership. That's 6.3.2 and statement number 100 on page 1.
yeah, right.
Yep.
But in the definition of temporary signage, it specifically mentions election signs, and you can have 5. It talks about signs in place for no more than 2 months in a calendar year, for 2 months prior to any national, state, or local election. Election is the key word there, and for 1 week thereafter, there may be up to 5 signs per lot. It should say 5
Of different people?
election signs per lots. Well,
That's, I mean, I read it
It's
as,
implied.
that's election signs.
right, that's how I read it too, yeah.
Yeah.
No, but I can see that you can read it the other way as well, but.
Yeah, but it's
You can
implied
put
with a
up
sentence.
I think so,
signs
too.
for schools if it's in the election season.
That's
Right. Is that how you read it?
what it allows.
Let's be realistic. How often is this going to be invoked?
Yeah.
Right.
Okay.
So I make a motion that we adopt the new proposed language under definitions number 4. In addition, a temporary sign is one that is on site that is for sale through a licensed real estate agent by owner or through advertising in a local newspaper of general circulation, but such temporary sign must be removed within 15 days of sale.
Second.
And also including language in 6.3.1 at the end of the sentence after section 6.3, quote, excluding real estate for sale signs.
Okay.
And adding the word temporary in 6.3.2.1.
Oh, okay. I asked if that was the only language, and I was told it was.
Temporary is added in 2 different places, 6.3.2 and 6, oh, I have 2 copies, never mind.
Yes, right. Okay, is there a second?
Second.
All those in favor?
Aye.
Aye. Opposed? Okay. We had minutes from, what was it, the 19th? Anybody have comments on the minutes from the 19th?
Move the minutes of March 19th.
Second.
All those in favor?
Aye.
Aye. Opposed? I make a motion, we adjourn.
Second.
All those in favor?
Aye.
Aye.
It's such a, getting out at like 8 or 9
Site
o'clock.
plan review,
Sleeves are like,
why
ugh.
is the review process?
Yeah, I know.